My Lord, I beg to mention item number 7, 9, and 27 on behalf of Learned Counsel P.D. Nair. May I pray that this matter may be listed on 4th of 7, 9, and 27.
Okay, who have you informed the other side?
Yes, Your Lordship.
9 also?
Yes, 7, 9, and 27.
27 also inform the other side.
Yes, yes.
And in all the case, you are for the petitioner.
No, Your Lordship. For
Okay, then one by one. 7.
in
Mr.
7,
Mr. Just a minute. Mr.
A Tatak.
Learned Counsel appearing on behalf of Mr. P.D. Nair, Learned Counsel for the petitioner, with the consent of the Learned Counsel for the respondent. Pray for, when do you want to say it?
4th May.
Listing this matter on 4th May.
May, Lordship. There is interim in item
The
number 7.
prayer is allowed. List this matter on 4th May. Stop. The interim order passed earlier shall continue till the next date of listings. And in 9, you are for?
In
9 also for the petitioner.
petitioner, Lordship.
Okay, 9 similar order.
Yes, and in 27 for private respondent.
27, I am for the petitioner.
You are for the petitioner, no objection.
No objection.
Okay, then here Mr. Sancho appearing on behalf of Mr. P.D. Nair and counsel for the respondent prays for this matter on 4th with Mr.
A Gamre.
Learned Counsel appearing on behalf of the petitioner has no objection. Prayer allowed. List it accordingly on 4th May. Okay.
Deeply obliged.
Lordship, I beg to mention item number 15 with 16.
This is for order.
Yes, Lordship. I've taken the concern of the other party.
Your Lordship, I'm appealing for the respondent.
Okay, no objection.
No objection.
As the leading counsel is outstation advocate, we fixed that date is 27 of March.
Why it has been listed for?
Order.
You are appearing on behalf of
Respondent. Diki Pangin, sir.
respondent number?
All the respondent. Then you know what 1 and 2 I guess. All to check, no? All of them.
Including 5 and 6.
Only the private respondents. Your Lordship, I will have to check about that.
Are you also representing 5 and 6 against whom step was taken last time? You have to share about.
Oh, copy.
Mr.
A Gamre, Lordship.
Learned Counsel for the
Petitioner.
Learned Counsel submits that
Oh.
the Mr. Niranjan Sharma, Learned Counsel for the appellant. He is out of station. Advocate who could not appear today due to his some personal difficulties. Therefore, pray for adjournment, to which Miss
Artakam, your lordship.
Land Council appearing on behalf of the respondent. There's no objection. Prayer allowed. Is prayed for. Prayer is prayed for. List is matter on
27 March.
27 March.
Yes, this month. 20
Friday.
27 March. Okay.
Much obliged.
May I please, Lordship? Lordship, item number 24, 25 and 26. Lordship, this is all part hard matter.
My lord will find
24?
25 and 26.
connected matter, my lord. The same accused
All-
arising out of same FIR
24, 25.
and 26.
Okay, what do you want?
My lord, on last occasion, on 14/8/25, my lord has heard this matter and keep this matter as part heard, my lord.
Okay.
So, but so far as my lord, the cause list is concerned, there is no any reflection that it's a part heard matter. So perhaps, my lord, if my lord is here, will hear this matter as a part heard, then in that case, my lord, this matter may be listed tomorrow, my lord.
Tomorrow.
Yes, my lord, because there are other matters are there. So perhaps for this matter,
This is a criminal petition for what?
my lord, regarding limitation, regarding taking cognizance, my lord. 468 earlier CRPC, my lord.
Okay.
Limitation period for taking cognizance, my lord.
Okay, okay. So, when do you want it said?
My lord, if it is part hard, then my lord make an,
Oh, hard and part.
okay.
Okay.
It is kept as part hard, my lord, but in, it was supposed to be listed after 3 weeks, but my lord,
Then. Oh, it will not be listed. So can you list it next Tuesday and
okay.
next Monday?
Okay, your
Your
lordship.
Lordship.
Okay.
30.
Yes, my lord, it's part hard matter.
30.
It's like a part hard only. Okay. On the prayer of both the land council for the party. List is matter on Monday is
30.
okay. 30. Okay, Monday.
It's part hard, my lord.
Obla.
Oblige.
May it pleases your lordship. My lord, I beg to mention item number 19 with the consent of the other side lordship.
Yes.
I beg to mention the matter to adjourn the matter because I have received the affidavit. I would like to file the rejoinder lordship.
Miss Ghosh, land council for the petition.
Interim order is there.
Submits that she had just received the affidavit and prays for some time to file, rejoin the prayer is allowed. List is matter.
On 21st, I humbly pray on 21st, my other matters are fixed
21st
of April lordship.
21st of April.
And lordship interim order is there in this case.
List it accordingly on 21st. The interim order passed earlier, so continue till then. Okay.
Deputized lordship. May I, Mr. Lordship, Lordship, I beg to mention item number 12, Lordship. Lordship.
Okay.
Item number 12,
Hmm.
Lordship. Lordship, can this matter be taken up on 9th of April, Lordship?
Who is for the?
Other side,
Okay,
I have taken
okay.
consent.
Miss Jiruba, huh? Oh, sorry, Riba Lanet. Additional senior government advocate for the state respondent with the consent of Mr. B. Sharma, Land Council for the petitioner, raised for listing this matter on
9th of April, Lordship.
9th April. Prayer allowed, listed accordingly on 9th. Okay.
Highly obliged.
My lordship, I wish to item number 8 on behalf of PG Nair. Due to some personal difficulty, he cannot able to present today. So matter may be list after 3 weeks.
So have you informed the other side?
Yeah.
Okay. Mr.
T Tagam,
Land Council submits that the conducting council, Mr. P.D. Nair, has some personal difficulties today and therefore prays for adjournment of the matter for 3 weeks. He has also obtained consent from the Land Council for the respondent. He has prayed for this matter on after 3 weeks. Okay.
Your Lordship, item number 21. I am for the respondents here. Both the councils are present, Your Lordship.
Hmm.
Here we have to file our affidavit, so we need some time. Kindly the matter may be fixed on 7th of May.
Mr. M. Kambo, Land Council for the respondent, pray for Father,
It may be fixed on 7th of May.
prays for Father time to file affidavit. To which Mr.
B. Kalita.
Land Council for the applicant has no objection. On the request of both the Land Council for the party, list this matter on 7
Of May.
May. Okay,
There is an interim order on
the interim in which,
FAO 5 of 2024. That may be
Okay.
extended.
the interim order passed earlier shall remain. And the shall continue till the next date. Okay,
Obliged.
it's final.
Yeah, please, your Lordship. Lordship, I beg to mention item number 14. Lordship, this matter can be fixed on 9th of April, Lordship. One another matter is already fixed.
Okay. On the prayer of Mr. D.
D.
Sharma,
Sharma.
Land Council for the
Interim order that may be continued, Lordship.
petitioner. List this matter on 9th.
9th of April, Lordship.
Okay. Who is appearing on behalf of the state? On which date the land additional the PP? Okay. Shall produce the updated case diary. Okay,
Lordship, interim order that may be continued.
the interim order passed earlier shall continue till then. Okay.
Highly obliged.
May I, Your Lordship? Your Lordship, I beg to mention item number 10. Lordship, the conducting council is out of station due to some certain difficulties. Therefore, Your Lordship, it is humbly prayed that this matter may be listed on 31st of March, Your Lordship.
Okay, Miss
O Jarang,
Land Council for Land Council submits that the conducting council, who is conducting council?
Your Lordship, go to Ribas.
Go to River. Land Council, submits that. Is go to River. Land Council for the appellant. There's some personal difficulties.
Yes, Your Lordship.
Therefore, pray for adjournment of the matter for.
Your Lordship, on 31st of March, Your
Pray
Lordship.
for the adjournment of the matter to be listed on 31st
1st of March.
of March. Okay,
Much
prayer is
obliged.
allowed. List it accordingly on 31st. Okay.
Much obliged.
Your Lordship, may I mention for an mentioning listing of an IA along with item number 22, which is listed today.
What is this for?
The
IA is for,
IA for impleadment of a respondent.
have you already filed?
Yes, I had already filed.
Okay.
My lord, I beg to mention item number 5, madam. Can my lord, it be taken up tomorrow, madam? Letting council is out of the station.
Okay. Let's pray for, list this matter tomorrow on.
My lord.
Write the date, huh? Okay.
Item number 1.
My Lordship.
Yes.
Application has been filed, Lordship, for press investigation over, Lordship, already. It's such it submitted by this police investigating authority. Kindly see, Lordship, page number 22. This is the prayer. Initially, Lordship, what happened? This investigation was carried out, Lordship, under this attempt to murder and criminal conspiracy. Kindly see the FIR, Lordship, previous FIR.
Page number 16 of the WP. It is section 126.
Yes.
Although this previous section was, can you see, previous section was 1092 oblique 61. Read it section 27 and after.
Yeah, where do we find?
Yes.
Why, where?
Previous FIR is page number 54. Previous section is when FIR was registered.
Yes.
This, after investigation, this FIR nature of allegation is nowhere connected with the search sheet submitted by the police investigating authorities. Kindly see, as per the page number 59, kindly see, this is the FSL report. As per the FSL report, kindly see, submitted by one Thomas Modi, ballistic expert, FSL PTC, Pandardua.
Page number
Page number 58, annexure 1.
50.
Yes. Page number 58, annexure 1.
Just a minute.
58.
Just a minute. 58.
Yes, 58 is 16.
Yes.
Yes. May I read the content? Nature of examination test conducted observation. I have examined the vehicle bearing number 1000 test part information of Itanagar Police Station on 27/10/2025 at around 1000 test. Suspected bullet for entry mark of diameter of 1000 test approx located in right side 1000 test. Found and corresponding exit hole was found in the inner side of the same door panel. The entry was tested positive for bullet hole using bullet hole testing kit. Accordingly, as per the FSL report, bullets were fired upon this complainant car over the running car. And as per all the FSL report, it was confirmed that bullet was fired upon them. They escaped. Even then, this search sheet has been filed under 126/35. That is a wrongful arrest under with common intention. Simply, every investigation part has been dropped by the eye of the case without assigning any reason. Nothing is said. Everything has been brushed off.
So at the time of firing, the door of the vehicle was open.
Yes. Here is nothing, any case of this using arm is not there as per this FSL report. Arm was used, but there is no mention of excess. The case is simply a wrongful arrest.
No. You have heard me properly, I don't know. Just at the time of firing,
Yes.
the door of the vehicle was open.
We have to see, read this case with the
No,
FIR.
just-
FIR.
just-
What is on the FIR? We have
Yeah,
to
in the
see
opinion, just see.
what is our allegation? Yes.
Here in the opinion, page 58, you have just read it. The door of the vehicle may have been in open position at the time of firing. Have you seen? Have you seen? Page 58.
Opinion 2.
Opinion 2. Okay.
This is may. Door of the vehicle may have been open position at the time of firing.
If the door was closed, bullets would have been found inside the vehicle, isn't it?
That is why we are complaining that investigation is faulty.
Investigation is faulty.
faulty investigation is
Okay.
there.
Mm.
That is why our prayer is there should be investigation over the investigation.
I wanted to confirm something,
Yes.
so you are diverting. Anyway, what is your submission?
That is why kindly see, this is although case was registered under attempt to murder,
Okay.
criminal conspiracy,
Mm.
using of arms against the complainant, firing over the moving car. And as per the FSL report, there was a mark of bullet injury over the car that has been confirmed. It was a parked car, it was a moving car, it is as per their opinion is otherwise, based on the above.
It was in the, it was
This is opinion.
the fire.
Yes.
Firing was during the at the time of firing, the vehicle was running. Okay, but the opinion is it's just opposite.
Yes, that is why we are claiming, reinvestigation over the case.
So that it should be
That is, investigation should be as per the FIR. Not
okay.
As,
So it should come into conclusion as per the
Yes.
FIR.
yes, as.
That
per
may
the-
not be
no,
possible.
As,
Mm.
I'm not saying so.
Mm.
Investigation should be in the line of this FIR. What had happened? There was a criminal conspiracy. Whether arms is one of the question, and whether attempt to murder was there or not, that is one of the question. Criminal conspiracy was there. But the case is simply wrongful restraint under common intention. That is our contention. That cannot be.
See, come to page 64. Findings. CCTV footage does not show any person carrying or firing any firearms. Findings. Have you seen?
That is why we are claiming we are the victim. We know what had happened.
Door of the moving car was clearly seen closed.
That is why
No sound or gunfire was heard by any independent witnesses. No bullet, firearm, 30 found, during investigation.
there were so many persons. It was the
Then come to page 65.
65.
Yes, statement of complainant. Have you seen?
Yes.
During investigation, the complainant categorically admitted that allegation relating to AK-47, NSCN cadre kidnapping, narcotic possession, and firing on 26/10/2025 were false and made under misconception. So
That may be that is why that is a part of the investigation. That may be overstatement of fact also. But it is a fact that there is a firing upon the complainant. That is there. It is not merely a wrongful restraint case. It is our case. There should be a proper investigation. There should be a
okay, yes, what do we do?
Sir.
At this stage, notice made.
No, my lord, may it please your lordship.
Mhm.
Your lordship, in fact, their writ petition consists of two different subject matter, my lord.
Mhm.
First, the FIR part, my lord, I will come to that. And the first part is regarding, my lord, the application of this Kumari Madhuri Patel case regarding APST issue. This got nothing to do with the present case, which my learned senior colleague is pressing before your lordship. Your lordship, there in their prayer, initially, my lord, second prayer is for, my lord, first prayer is for a fresh investigation. My lord will find the second prayer for clubbing investigation together to the complaint dated 1/8/2025 and the FIR dated 27/10/2000. It's written 20
What
paragraph
is
is
that?
2025. So my lord, how this investigation club with the complaint dated 1/8/2022. My lord, may kindly come to that complaint, my lord.
What is this complaint? Which
Yes.
one?
My lord,
this complaint is talking about which complaint?
My
The
page
present
number,
one.
no, my lord, different one, page 44. My lord, may kindly come to page 44, Annexer G. This complaint got nothing to do with the FIR, my lord. Here, they have written to the chief secretary and the commissioner political, subject, my lord, complaint in continuation of representation dated so and so, in respect of issue of APST certificate, my lord. With procedural law laid down by the apex court in Kumari, Madhuri Patel and another versus so and so. It will take its own course, my lord. The second is investigation by senior DSP and the other so and so who can claim. My lord, these are the procedures specifically laid down by the Supreme Court in Kumari, Madhuri Patel. Why, my lord, they are seeking the clubbing of the FIR with this complaint, my lord? One is regarding the validity of the ST, and second is regarding the assault to the present writ petitioner, my lord. The prayer itself will not sustain, my lord. Second prayer, my lord. There is nothing mentioned about, my lord, the assault thing. It has a direct connection with the assault. So this is the totally different subject, my lord. And if they are aggrieved, my lord, the 226 would lie. But so far as, my lord, the criminal case is concerned, investigation completed. Now, my lord, they have not stated in their writ petition whether cognizance has been taken or not. If cognizance is supposedly taken, then my lord, writ of mandamus will not be maintainable, my lord.
What is the latest stage of the case?
Charge sheet file, my lord, according
Charge
to
sheet,
the...
or the charge sheet filed, but then what is the stage?
It is yet to be this taken of cognizance.
Okay, not
to be
yet.
cognizance.
Okay, charge sheet filed, when the charge sheet was filed?
Kindly see this. This I think is charge sheet. It is put on the date. Final report.
Where is charge sheet?
23 January 2026. Final report. Page number 60. Dated 23rd January 2026.
Yes.
So, my lord, we don't know whether the cognizance has been taken or not as on that. Now, my lord, they come to the this charge sheet part, my lord. My lord, they have to prima facie satisfy that the investigation agency has ignored a substantial thing. Because of that, the prejudice caused to the present writ petitioner. Here, my lord, ballistic report. No doubt, my lord, the bullet was there. It entered in the door and exit from the door side only. And so far as the ballistic opinion is concerned, it has stated, clearly opinion has been given, that the door, at the time when it was fired, the door may have opened, my lord. My lord, the ballistic expert cannot say it like a, do not have give a judicial finding. But so far as the prima facie case, prima facie section is concerned, the 27(1) is concerned, my lord, it has to be consonance with the allegation, my lord. They have stated in the FIR, the car was running. In the running car, it was fired, my lord. But, my lord, as per the ballistic report, it was not fired in the running car, and CCTV is there. All the material has been properly collected, my lord.
Yes.
There is no scope for new investigation. CCTV is collected, and my lord, the independent witnesses, my lord, will find their this independent witnesses has clearly stated that there was no any sound of fire also. In fact, my lord, if we go for further investigation, my lord, it may come to the conclusion he himself is involved in doing all these things because the ballistic is not supporting their case, my lord.
It looks like that.
Yes, my lord.
And then because they see the statement, his statement.
Yes, ma'am.
That was false regarding carrying of the AK-47.
Yes, my lord. Absolutely, my lord.
He himself says it's false. And then he regrets for making such false and serious allegations.
Yes, absolutely, my lord.
Trouble. He will be landed into trouble, Land Council.
In fact, my lord, he is liable to be a case section is there in the BNSS for my lord alleging wrong information to the public servant, my lord, to investigate the matter. Here he himself has admitted that allegation relating to AK-47, NACN, Kedar, kidnapping, narcotics, so and so, firing on so and so were false and made under misconception, my lord. He expressed regret for making such false and serious allegation, my lord.
CCTV footage are there, and then under the circumstances, the new investigation will be focused, it will be directed towards you only. Who caused this whole?
Kindly, the lordship, Honestly, as per instruction lordship, that is not the. That is otherwise lordship. This
Ah.
is my case is lordship. There is a complaint.
Ah.
The issue was ground for tussle in between the parties. There was a group clashes. This is a group of some non-APS.
Some commotions were there.
Yes,
Hmm.
commotion was there. That is why everything was recorded.
No
on the
sounds,
CCTV.
no arm,
that-
no person
when
carrying any
surprised-
arms.
We are surprised to see the final report, how it had happened. Because we know what had happened here. Even then, this is the case. That is our.
Surprised what?
Yes, we're surprised.
Surprised what?
Surprised.
How the?
How we're surprised to see it. Even after firing upon our car, number one, and section 27 was inserted. This attempt to murder was there. Criminal conspiracy was done by this one Sabandia. This is
My-
Sabandia, engineer Sabandia. He that's the conspiracy, as per their this allegation. That is why. Even then, everything has been manipulated. How come? That is why. At this stage, notice may go and we
At
will-
most, my lord, what they can do
status report may
is they can approach the trial. Now, my lord, admittedly, they are saying the cognizance not been taken. Now, there is no any requirement for fresh investigation, as your lordship has clearly seen. Every material which was involved in the offense has been truly investigated, collected by the investigation authority. If they are still think that there are some material which has not been collected, then they can always pray for further investigation before the trial court, my lord. There is no any, my lord, there is nothing from the record to show that any prejudice caused to the accused person or this victim person. In fact, my lord, as my lord has clearly rightly pointed out, he himself has admitted, my lord, that he regret to making a false and serious allegation, my lord. And now he's coming before the court and saying that investigation was not properly done. And that too come with two different subject matter. So, my lord, in my humble prayer is, my lord, this writ petition, this kind of writ petition should not be, my lord, entertained with, and it should, my lord, it may be disposed of at Lemine by imposing cost, my lord.
Lordship, here I am for respondent number 2 and 3, Lordship.
Okay,
Chief
okay.
Chief Secretary and Commissioner. Lordship.
Okay.
While supporting the,
Is there any grievance against you?
no, Lordship, this is why, Lordship, from paragraph 1 to 6. The subject matter is the issuance of certificate, APST certificate to the petitioner, Lordship. How this can be clubbed together, Lordship? This subject matter is totally different, Lordship. And in pleading, he's not whispering this also. No, look. Our name, our respondent, Lordship, our party may be deleted in that case, Lordship.
No, your
If
prayer,
not
your
executed.
prayer is different, it appears. And then
Yeah.
the
But-
impleadment, you have impleaded the chief secretary, commissioner, political.
And Lordship, in the pleading is there from para 1 to 6.
Hmm.
The grievances against respondent number 2 and 3. To consider the representation or complaint submitted to the respondent number 2 and 3. That is chief secretary and commissioner political.
What was the representation?
Issues are totally different, so Lordship, this could not have been clubbed together with this DNS. Lordship, part, Lordship.
So what do you do?
What
do
may
you
be
want to do?
dismissed, Lordship, this writ petition may be dismissed, Lordship. My prayer is that
we can,
with cost.
Lordship, basically, Lordship, the matter hasn't, there is a complaint, that is why.
Yes, it will be difficult,
complaint-
The claim, the prayer,
Yes, club
two
together.
prayer
Yes, club.
is altogether different.
clubbing
it will be
of the
difficult.
case- Clubbing of the case with the pending case or not, that is, that may be or that may not be, that is not an issue.
Okay,
That may be dropped. But our concern is The primary concern is this pair investigation. Our-
Okay, then,
our
then,
matter-
probably you have
Pair
to
investigation.
separate it. Then probably you have to separate it.
Yes.
Then in that case, what do we do? You want to withdraw and file separate?
File fresh.
That will be better.
Yes.
You just study properly.
Yes.
And detailed reports are there.
Yes.
Okay,
File fresh as per the relevant provision of law.
right. Mr. D. Dapak, Planning Council for the petitioner at this stage wants to withdraw this writ petition with liberty to file FS, file an appropriate application. Appropriate application. Start. Huh? Mr. Okay, to which Mr. Lanet, additional senior government advocate, and Mr. P. Lanet, additional PP has no opposition. Prayer allowed. This writ petition, criminal, huh? Is dismissed on withdrawal with liberty is prayed for. Okay.
Item number 2.
May I please go?
Yes.
So item number 2 and 3, it's connected with the same petitioners, but really for different also. In item number 2, Lordship, the petitioner before your Lordship is challenging the suspension order. In fact, suspension, Lordship, it was issued on 12/8/2025. May I take you to the annexer 7, page 41, Lordship. 41.
Page
41, Lordship. Annexer 7.
Yes.
This suspension order was issued on 12 August 2025, but it was signed on 20 August 2025, Lordship. May I read, Lordship? Whereas a disciplinary proceeding against Sri so-and-so, he is the petitioner, Executive Engineer Auto, State Transport Services is underway in connection with malpractice in awarding work contract and thereby incurring unauthorized expenditure. This is the allegation, Lordship. Now, therefore, in exercise of powers conferred under sub rule 1 of rule 10 of the Civil Services Classification Control and Appeal Rules 1965, Sri so-and-so, State Transport Services is hereby placed under suspension with immediate effect. During the period of this order remaining in force, Sri so-and-so, State Transport Services shall be attached in the office STS station under which he stands transferred by government so-and-so dated 7/5/25 and said Sri so-and-so officiating shall not leave the headquarters without obtaining permission of the General Manager ST. Now, Lordship, after issuance of this suspension order or 12 August, now it's been 215 days, more than 7 months, Lordship. My suspension order was not reviewed, nor any departmental inquiries under initiated, and no memorandum served to the petitioner. But the petitioners are kept under suspension for long period.
So, no review. So, what issue notice?
Yes, my lords may be issued, my lord. Because if you stays, my lord, that will tantamount to final order, my lord. So notice may be issued, my lord, in this case.
I'm not praying for still.
We'll just issue notice at the moment.
Only instruction can also, Lordship.
Instruction or what? Instruction?
My lord, instead of instruction, my lord, let notice be issued, my lord. We will try to file it as soon as possible, my lord. Instruction at the most what, my lord, whether we have reviewed or not, my lord.
And not issuing,
And-
notice will be better.
Notice will be better.
So that we can pass an order.
Without that, Lordship.
Okay. Heard Mr. K. Lole, Lana Council for the
Instruction.
petitioner. Also heard Mr. R.S. Navam, Lana additional AG for the state respondent.
All our official respondents, my lord.
All the official state respondent. All are official respondent.
Official respondent.
Okay. Start. The case of the petitioner is that by an order dated 12/8/2025, issued by the respondent number. Who issued this interim order?
Lordship,
Commissioner,
No,
two.
Commissioner, it's
Commissioner Lordship,
Commission.
signed by the under secretary.
doesn't matter.
It was
Okay.
respondent number 2, Lordship.
Respondent number 2. The petitioner was placed under suspension. So the petitioner, sorry, the respondent authority in exercise of the power conferred under sub-rule 1 of Rule 10 of the Central Civil Service Classification, Control and Appeal, Rule 965, the petitioner was placed under suspension. Stop. It is submitted that suspension with immediate effect. With immediate effect. However, after placing him under suspension, although how many days you said?
215 days, Lordship.
215 days has expired after 90 days period. After 90 days period,
Lordship.
it has to be reviewed within
Yeah,
90
yeah.
days.
Before expiry of 90 days, it has to be reviewed.
Yes, but then
But then it
this
will-
215 is after 90 days.
No, Lordship.
Okay, total.
Total.
Okay, has expired. However, the suspension order was has neither reviewed nor revoked by allowing the petitioner to rejoin his service in violation of Rule 10 within bracket 6 and 7,
Lordship.
which provides an order of suspension made or deemed to have been order of suspension under deemed to have been made under sub rule 1 or 2 of the said rule shall not be valid after a period of 90 days unless it is extended after review.
Yes.
Before the expiry of 90 days. Start. Okay, issue notice. Returnable by,
My lord, 3 weeks, my lord.
okay, 3 weeks. Start. Since Mr. R.S. Nabamlan, additional AG, appeared and accepted notice on behalf of all the state office respondent, no formal notice need be issued. Start. However, the petitioner shall furnish requisite extra copy to the Lanet additional AG during the course of the days. Start. List it on list
After 3 weeks, my lord, no date.
Okay.
Three also same logic.
Okay.
Item number 3 also connected.
3 connected.
Three also will
I
issue
permit,
notice.
Lordship. 3
Sir.
is regarding payment of subsistence allowance. Lordship.
Okay.
I have been placed under suspension.
Okay, then
from
3
under-
hard, huh? It is the same only. The it is some after hearing, it is submitted that there also you are accepting notice.
My lord,
Okay.
1 to 5, my lord.
First paragraph will be sent, kept under suspension. However, since suspension, the petitioner has not been paid subsistence allowance. Okay.
Lordship, here, Lordship, the petitioner and his entire family are suffering because of
Mhm.
non-payment.
Okay.
Lordship, this is urgency in nature because this is violation of right to life, Lordship. Since August, I'm not saying any subsistence allowance. Lordship, this can be. My senior.
So here instruction can be obtained also.
My lord, substances allows, my lord, they are entitled, my lord, since it's more than, my lord, 6 months, my lord, 7 months.
Yeah.
My lord, 50% your lordship can direct, my lord, to release, my lord, substance allowance, no issue for that, my lord.
Okay. So
They're entitled. for-
then in the interim, it is provided that if the petitioner has not been released his subsistence allowance, the state respondent is directed to release the subsistence allowance entitled to the petitioner.
My lord, from my lord, that
From
is.
from the date of his suspension.
12/8/2025.
That is 12/8/2025 till date, huh?
Yes, but
He is entitled to the petition, okay?
Under law, my lord. Yes,
Under the, under the,
Under my lord.
under the,
53.
okay, as per,
Fundamental rules.
as per the fundamental rule 53 and other relevant rules,
My lord.
Yes,
as is applicable in the case of the petitioner.
yes.
Okay,
Ma-
this is matter after 3 weeks,
Weeks.
Okay.
What method will also apply today?
okay?
Please, your lordship, item number 12 and 14, I have prayed to fix this matter on 9th, lordship. 9th is the lordship assembly election polling day in Assam, lordship. Can it be on 10th?
10th, huh?
Item number 4.
Yes,
This is issue
Yeah.
minus something
Hmm.
really unheard of. Petitioner my lord was serving as assistant registrar
Uh-huh.
in the establishment branch.
uh-huh,
Now, at that point of time, your lordship have page 22. Time out.
it's 22.
Alright.
Yes,
This is a representation by the Students' Union of Merit, alleging certain allegations against me. From last paragraph, your lordship, kindly see. We wish to bring to your attention a serious concern regarding the credibility and conduct of Eastern
last paragraph is at page,
22. The third
page
The
22.
third paragraph.
Okay,
only.
okay. Mhm.
Bring to your attention a matter of serious concern regarding the credibility and conduct of instance registered such and such over appointments in numbers of posts. It has come to light that we eligibly facilitated the appointment of post family related to various posts with marriage to non-parents such and such, such and such. So they have given the list at the next page. This is in fact incorrect. The person as serial number 2 was appointed through a selection process and others are employees of a farm minor,
Hmm.
outsourcing firm engaged by the nearest. In any case, I am not on that matter. So these are the allegations. Then at page 24, they are demanded to the second last paragraph. Such practices, as the lordship got it. Page 24.
Hmm.
Such practices not only damage the reputation of the university, but also demoralize deserving candidates and erode public trust. In the light of the above, some demands that such and such should be removed immediately without further delay and should not be posted in sensitive posts like such and such, such and such. So this is their demand. There are other demands also, we are not concerned with them. This is other grievances. Then your lordship.
Other grievances are also against you.
No,
Okay.
these are different. I am only in respect of that.
Hmm.
Then your lordship will have page 29. Similar allegation this time by the answer. 2 days later. First allegation is 1711. Second is 1911. Another,
This is specifically against you.
yes.
Okay.
Now succumbing to this, but at page 31, a meeting is held between these students' organizations, self-styled organization, they are not even registered organization, and the director of NERIST and 2 other officials of the NERIST. And they take this decision. In the meeting, the following decisions are taken. Minutes of the meeting held on 20 with Director NERIST, President such and such, APSU also involved thereafter. President ANSU and other APSU, ANSU and SUN, Student Union of NERIST. And its executive members, Registrar, in charge Dean, Student Affairs and Dean Administration. In the meeting, the following decisions are taken. Mr. such and such will not be placed in sensitive post. Then thereafter, succumbing to this at 212 is the transfer order. But how can in a country governed by rule of law, such type of decisions can be taken, my lord? I am not, my lord, for a moment now, this is my clear instruction, that I am not seeking a stay of this order, transfer order. Very well, I have been transferred, but this minus, my lord, cannot stand, even for a second, my lord. This is absolutely illegal, arbitrary, unconstitutional. And this is a stigmatic transfer, my lord. There are allegations, true or not, we don't know. But there is a procedure established by law, my lord, to come to a conclusion of misconduct by an employee. NERIS does not have its own misconduct rules. They follow the CCA rules. So in such case, so-called notices will have to be issued. A memorandum of charge has to be issued, my lord. Thereafter, there will have to be a departmental inquiry to come to such a finding. How can, my lord, a meeting be held with self-styled organizations and this decision can be taken, my lord? This is not a prima facie case of arbitrariness. It is an apparent case of arbitrariness, my lord. It is an illegal minutes. So it is says, my lord, I'm praying for notice and let the minutes be, my lord, state. I am not asking that I should be placed back there. Transfer, let it be there, but the minutes cannot be allowed to extend even for a second, my lord. This is absolutely illegal. I'm sure my learned friend also.
Yes.
This is, my lord.
My lord, I am for the respondent number one, my lord.
Hmm?
Respondent number one, my lord.
Okay.
Our other respondent, my lord, there is have their own standing council. However, my lord, this NERIS comes under the Ministry of, my lord, Ministry of the Higher Education, my lord.
Okay.
So, my lord, my respecting submission, my lord, if such is the, my lord, situation, there is no separate proceedings. And there is no, my lord, the other, my lord, the initiation from the NERIS authority, my lord. If tomorrow, my lord, if this student organization, my lord, protest, this high court should be removed from somewhere, removed to somewhere, my lord.
My lord, because this happened earlier also.
This
But-
cannot be, my lord, to my respectful, my lord, understand, my lord.
This is apparently, my lord, illegal, my lord, page 31. I am seeking only stay of this, my lord. Let the transfer be there. I have already posted out.
There may be, my lord, the demand from the many
The
organizations.
only point number one is against you.
Yes, yes. Others are for others, man.
My lord, there may be so many demands from the any organization. However, my lord, as an institution established under the, my lord, the statute, my lord, has to, my lord, consider its own merits, my lord, not on the pressure of the anybody else, my lord.
And how can an statutory authority, my lord, act like this?
That is my response, submission, my lord.
We're governed by a set of rules of law.
UFO?
Lordship, I'm appearing for NERIS on behalf of Senior Advocate Mr. Reappa.
Okay. NERIS is respondent number
Respondent number
2,
two.
3, 4, 5, 6. Okay. 5 and 6 are? They are also.
They are also officers. They were there in the meeting, my lord. That is why.
Okay.
NERIS Standing Council will take notice on behalf of them. They are officers.
Policeman notice then.
And my lord will kindly stay the minutes of the meeting in respect of me. Close one. If this is allowed to extend.
You are agree by, not by the transfer.
Transfer, my lord, let it be there. It's okay. The minutes of the meeting, my lord. I have challenged the transfer, but I will not press it, man. But this has to go. This is stigmatic, my lord. I'm a government officer. This will remain in my service career.
Okay. Mr. Deepang, Council for the petitioner. I also have Ms. Kapil and DSTI for the respondent, respondent number one, respondent number one,
Melon.
and Ms. appearing on behalf of Mr. A. Apang, Line Female Council, Line Senior Council, Standing Council for the Ladies. The petitioner challenges the challenges.
The decision
Minor.
taken,
Okay, the minute dated 28/11/2025, whereby the petitioner whereby it was decided that the petitioner will not be placed in sensitive post, that is in establishment, finance section, confidential, sale, legal, and store and purchase. And the next is you are also challenging.
the transfer order dated 2/12. But I will
And
not go
and
to
the
press
consequential transfer order dated
2/12/2025.
2/12/2025. On the ground of the same being issued on the pressure, on the influence of
Yes.
on the influence of,
Various student organizations.
okay, on the ground that the said order was issued on the basis of the allegation made by the student organization
Without conducting any inquiry.
without conducting any inquiry nor or giving opportunity to the petitioner. Stop, huh? The Lani Council for the petitioner submits that such transfer based on the allegation of the student organization is an stigmatic. Stop, huh? Therefore, pray for passing of the same stuff, para issue notice. Since Mr. Pato, Lana DSTI, appeared and accepted notice on behalf of the respondent number one, and Ms. Sun Soha appearing on behalf of Mr. A. Apang, Lana Senior Council, Standing Council for the Ladies. For ladies, no formal notice may be issued. Start. You serve extra copy?
By tomorrow.
Okay. However, the petitioner shall furnish requisite extra copy to the learned counsel appearing on behalf of the respondent. Start. Para. List this matter after 3 weeks.
Well.
Okay. In the meantime, it is provided that the operation of the minute of the meeting dated 28/11/2027.
25.
Sorry, 2025 shall be. Because it,
In respect of the petitioner.
in respect of the petitioner, it's a decision number 1.
Yes. Decision number 1.
The cell. We'll say at the moment, subject to the outcome of this writ petition. At the moment,
My lord, I'm.
supposing if it stays,
This is not a
if it's,
private.
because pursuant to this, already transferred.
The my lord will make it clear
Huh.
that the petitioner is not pressing
Huh.
for cancellation of the stay of the transfer order.
Huh.
Only this illegal minus may be statement
In respect of petitioner.
in respect of the petition. I don't want to go back there. That is not my case. But how can this be allowed to stand? This is not a prima facie case, my lord. This is an apparent manner on the face of the record.
This may, since you are not pressing, this may have to go next time,
My lord,
this order.
which one, my lord?
Because in pursuant to,
Yeah, I have understood, my lord.
Hmm.
But my lord may say,
Hmm.
may observe my prayer that I am not pressing for the stay of the transfer order.
okay. Okay.
But how can these minors be allowed to stand?
Hmm.
Even for a second.
Then the next para, however, at this stage, the Lana Council for the petitioner submits that he is not pressing for, and pressing against the transfer of the petitioner from establishment branch to examination cell, or where is the other one?
The other one has been kept in abeyance, my lord.
Okay. Okay. In view of the, upon hearing the parties and in view of the above submission of the Lana Council for the petitioner, in the interim, it is provided that the operation of the minutes of meeting dated 28/11/2025 in respect of the petitioner Sri Doge Kamdo shall remain state.
Okay.
Okay. Stop. Leave this matter after 3 weeks.
My lord.
Okay.
Okay.
Deplorable.
Item number 6.
It will say remain suspended. Huh? Till the next date, huh?
May I plead your lordship?
Yes.
My lord, the petitioners 8 in numbers, my lord, they are aggrieved with this annexure 18 and 19 of page 108, my lord. Although they are not aggrieved with the constitution of DPC and preparation of seniority list, my lord, they are aggrieved with certain findings and observations which are recorded in the DPC and in the seniority list, because these things will, my lord, seriously cause prejudice on the seniority of the petitioners, my lord. Your lordship may kindly peruse page 108, my lord. This is the DPC, my lord, DPC meeting. On recommendation of the Departmental Promotion Committee meeting held on 15/10/2025, the Governor of Arunachal Pradesh is pleased to order the promotion of the following assistant engineer to the post of executive engineer, civil group A, gazetted, my lord. So the contention, my lord, of the petitioner is that these 8 petitioners, they never served as assistant engineers, my lord. This is wrongly recorded. They served as prior.
8 petitioners
Yes, my lord.
never served as,
Assistant engineer.
okay.
Before being promoted to as executive engineer, my lord, they served as deputy director, my lord. And the post
Okay. Just a minute. And here it is mentioned as
assistant engineer, my lord.
promotion of the following assistant engineer. You agree by this?
Yes, ma'am.
They were never been in the in the post of assistant engineer.
Yes, ma'am. And
Okay.
and that is number 1 grievance, my lord. Number 2 grievance is, my lord, this DPC should have been, my lord, constituted for regularization, my lord. Because these 8 petitioners, they were serving as deputy director on officiating basis, my lord. They were serving as deputy director on officiating basis, my lord. So basically, my lord, the DPC should have been constituted for regularization
They were serving as deputy director on officiating basis.
Yes, my lord.
Officiating.
Yes, against existing vacancies, my lord.
Not as assistant engineer.
No, my lord.
Okay.
And
So this is one.
yes,
Okay. The other one is?
other one is, my lord, down below in the list, my lord, their relative intersectionality shall be determined subject to the outcome of the court order in WPC number 572 AP 2016, my lord.
Oh, this is pending.
Yes, but they have nothing to do with this writ petition, my lord.
Okay.
They are not even interested party. They have not been made a respondent, my lord.
Okay. No, nowhere connected.
Yes, my lord.
Okay.
So by filing this writ petition, my lord, they have basically prayed for retrospective promotion, my lord. That is from the date of their officiating appointment, officiating promotion as deputy director, my lord.
When they were promoted as deputy director?
No, they were 2015, my lord. Way back in 2015. This is, lordship, their promotion is at page 88, my lord. Page 88, my lord. Annexure 13. Page 88.
Yes.
May I read, my lord? In the
Yes.
interest of public services, the governor of Arunachal Pradesh is pleased to promote the following urban program officers to the post of deputy director, UDN housing in the pay scale of so and so. The officiating promotion shall be regularized through a duly constituted departmental promotion committee board, my lord. So initially, my lord, these petitioners, they were appointed as AUPO, Assistant Urban Program Officer. Then from that, they were promoted to UPO, Urban Program Officer. After that, from UPO, they were promoted to Deputy Directors, my lord, on officiating basis, my lord. So here in the DPC itself, my lord, it is clearly recorded that their officiating promotion shall be regularized through a duly constituted DPC, my lord. So basically, this impugned DPC should have been for regularization of their officiating service instead of promotion from assistant engineer to EE, my lord.
So according to you, they should have been regularized in the post of deputy director.
Yes, no, executive engineer, my lord. Executive engineer. Yeah. Because, my lord, this
No, post of deputy director is equivalent to
executive.
executive engineer.
Yes.
Okay.
My lord,
Nomenclature was changed, madam.
yes, this deputy post of deputy director, lordship, this was redesignated to the post of executive engineer, my.
Okay.
This is at page 90, my. The governor of Arunachal Pradesh is pleased to redesignate the following technical posts of UDN Housing Department to maintain a common designation with other analogous engineering technical posts in various works department under the government of Arunachal Pradesh. So out of these 6, my lord, the deputy director civil
Okay. So
has been
so their promotion to the post of deputy director was from the post of
UPO, urban
UPO
program
only.
officer.
Okay. So they were never
They
in
never
the
served
in
as
the post.
assistant engineer.
Okay. Assistant engineer. So your grievance is only two, that this should be a regularization from retrospective effect
Yes, ma'am.
and in the post of executive engineer. Okay.
So, lordship, at this stage,
Okay.
notice may
So-
kindly issued, my.
My lord, at this stage, notice may be issued, but little bit clarification, my lord.
Okay.
Page 90,
Mm.
what the Land Council for the petition is saying, my lord,
Mm.
they were never served as assistant engineer, my lord.
Mhm.
It's not correct, my lord. If your lordship sees, my lord, present designation and redesignation, my lord. They were serving as mother UPO, urban program officer,
Yes, that is now has become assistant
assistant
engineer.
engineer. So assistant engineer is the bigger post for the executive engineer. That is the deputy director, my lord. Right, my lord? So DPCP lordship Peros, my lord, they have used, my lord, instead of this
Instead of
bureaucrat,
UPO.
they've used, my lord, technical word, my lord, injured technical assistant engineer, my lord.
Mhm.
Assistant engineer to executive engineer. At the most, what they can say, my lord, they have been not given a retrospective promotion, my lord.
Mhm.
That exactly, I think, that is the moot question before your
Right.
lordship, my lord, whether they are entitled for retrospective promotion or not, my lord.
Mhm.
So, my lord, as this state notice may be issued, my lord, no problem for that, my lord.
Hard Mr. N. Pada, Line Counsel for the petitioner. Also hard Mr. Aris Navi, Line additional review for this,
All, my lord, 1 to 4.
for the state respondent number 1 to 4. Starts para. The the case of the petitioner is that the petitioner 8 in numbers were promoted from the urban program officer to the post of deputy director by order dated 15/12/2015. And whereby it is stated that the officiating on the official on officiating basis staff, it is submitted that the officiating promotion in the said order it is mentioned that the officiating promotion of the petitioner shall be regularized through a duly constituted departmental promotion committee staff. It is further submitted that by an order dated 27 just a minute. By filing this writ petition, the non-counsel for the petitioner, the petitioner is aggrieved by the order dated 27/10/2025, whereby it is mentioned that the petitioner have been promoted from the post of assistant engineer civil to the post of executive engineer with effect from the date of DPC, that is 15/10/2025. Stop. The grievance of the petitioner is that they were never, they have never served as in the post of assistant engineer. Their subsistent post before change of the nomenclature was the R1 program officer from where they had been promoted to the post of deputy director on officiating basis. The further grievance of the petitioner is that they were since they were serving as the deputy director within bracket UDNH since 15/12/2025. Their service were to be their service were to be regularized with effect from the said date. However, by the impugn order dated 27/10/2025, they have been promoted to the post of executive engineer within bracket, to the post of deputy director within bracket, now executive engineer, with effect from the date of DPC. Therefore, pray for. Regularization of their post, regulation of their service to the post of executive engineer instead of being promoted from assistant engineer, with retrospective effect from the date of their officiating promotion to the post that is from 15/12/2015 instead of the date of DPC, that is 27/10/2025, at par with other similarly situated persons. Staff of Paras issue notice. Since Mr. R.S. Naned, additional AG, has appeared and accepted notice on behalf of all the respondent number 1 through 4, no formal notice need be issued. Staff, however, the petitioner shall furnish requisite extra copy to the Naned additional AG within 2 days from today. Staff, please this matter after
4 weeks, my
4
lord.
weeks.
Okay. Deeply obliged. Matter number 11.
Yes. Lordship, we have accepted we have exchanged the copy of the rejoinder at the file. Honorable Court is ready to dispose the matter. They will hear the matter. This is IA. IA is for what? IA is here.
Lordship, I is for vacation of order dated 29 passed by this honorable court, granting interim order, Lordship.
What is this matter about writ petition? About a transparent posting. Transparent posting. Yes. And then by this, that was state. State.
Yes, Lordship.
Okay. Transfer order is state. The entire matter can be heard.
Yes, Lordship.
Okay. Today?
Yeah.
Okay.
Small matter.
Just a minute. May Lordship, I think the petitioner. Just a minute, Can you see the writ petition log? Copy of the writ petition. Yes. Entire case is emanated from 18 enacted one. Just a minute, yeah. Right? I. 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 Yes.
Kindly see page number 18, annexure 1. This is the genesis of the case. Kindly read the contents.
Yes.
I have filed this writ petition because this impugn transparent posting order is bad in law, which is violation of the Article 14 of the Constitution of India. That is my first leg of argument. Because Lordship kindly read this impugn order, 18 April of 2025. It says, admitted position of the fact is that both are drivers and private respondent as well as me have already stayed as per the this standing notification transfer posting regulation. We have already stayed as per the norm, but this equal transparent posting order has been issued on the request of the private respondent, not on, and the order has been not issued in a
This seems like mutual. This seems like mutual transfer.
no,
Okay.
neither in exigency of government services nor on public interest, but on personal request. Because kindly see, it was the district administration was taking side of the private respondent and processed the application for transfer posting order on the request of the private respondent without hearing my grievances. That cannot be. Because this is a government office, public office. The government authority is supposed to hear both the parties and treated the parties equally. Because in this order, this Parang Ali, the private respondent, has been shown a first mode at his own request. This transfer order has been issued at own request. When the transfer order is issued on own request, when the government refused to hear the grievances of the other party.
Okay. The person in the serial number 1
serial number
made a request, and the transfer order, according to you, had issued on his at his request.
Parang Ali is number 1 and I am number 2.
Okay.
Number 1 has been transferred from CHC Mariang to CHC 2 thing as first move on at own request.
Okay.
And then kindly see last line. They should report to their respective medical officer insert for further duties. No representation of this order will be entertained. And
Okay. By the way, when you were transferred to Ting?
This is the admitted position of the fact is that I have stayed at Tooting more than 2 years. Generally, 2 years is the criteria for a particular station as per
Okay. So
okay,
as per the
I'm
scheme.
not saying it is an image to transfer.
Okay.
This is not a case. The case is this is a
At the instance of the
transfer
at the instance of the
at the
respondent.
request of the private respondent,
neglecting
my grievances when I try to apprise my grievances before the authority. They refuse to entertain my.
And a private respondent also have been in the said place, CH Mariang, for more than 2 years.
Yeah, he has
Okay.
been also in Mariang for more than 2 years.
Okay.
That is
So
that's true. Both
Okay.
in both the
both otherwise can be transferred.
mature transfer, administrative authority can take the decision. But in the instant case, Lordship, the transfer cannot be issued in such a manner because when the government is ready to hear the other party, private respondent, the duty of the government is also hear my part also. Because I have a family, I have a little children. The authority is to hear my grievances. When to transfer, when to not to transfer. The authority is supposed to accommodate my grievances. Apart from obliging this government duty, I'm obliging, I'm complying all this government rule and notification. But kindly see page number 14, page number 19, annexure 2. This is my representation. When this representation was submitted along with this medical certificate and school, because my children are there at Tuting. There at Tuting. But when I approach the competent authority to express my grievances, saying that I may be retained there for some time. And I also personally request the private respondent because since they are staying at Mariang, and I may be accommodated, but the authority says no representation will be entertained. That is arbitrary, because authority is supposed to hear, being the model employer of this state, the authority is supposed to hear my grievances. When the employee is having grievances, having family hardships, in that case, the authority is supposed to hear. And in this manner, the transfer order cannot be issued. Because when such transfer is issued on personal request, sidelining the other party and not hearing the other party, and when the transfer and posting order is not issued on public interest or not in exigency of government services, then that is bad in law. That is called the arbitrary exercise of power. When the administrative decision is arbitrary exercise of power, this honorable court has the power and jurisdiction to direct the authority either to consider the application as per the due process of law, while taking into consideration of both sides of the part, both sides, to consider the grievances of both sides. And although the private respondent has supported this reportedly joined a truthing as in terms of this as per the government affidavit at truthing, but their children.
When?
Can you see this as per the government affidavit? They have said as per the government.
25 April 2025.
Yeah. 25 April. They're claiming, government is claiming, yes, admittedly, government is claiming 25 April 2025, they have joined. But the respondent side has not shown any, their word, not shown any record to show that their word has joined there. They have been transferred because they have children. I have also children, school going children, they have also children. My children are admitted here at Tupi, and their children are yet to be joined here. They are residing somewhere, although they have technically joined at Tupi. So purportedly joined at Tupi on 25 April 2025. Under these circumstances, my point of argument is lordship. Transfer and posting order cannot be issued in such a manner. The authority is supposed to listen my grievances in terms of various court things here. The authority is supposed to hear the grievances. When such order is issued on not on public interest, that is supposed that may be interfered. That is why lordship. This is a big case. Your lordship may interfere over the impugn order, and my representation is here. At the same time, while setting aside this impugn order, my pending application before this authority, district medical officer, that may be considered, taking into consideration of ground level situation, because we are having family member and petty government job, that is a driver. In both the case, there is nothing any speciality, because I am performing my duty at Tuting. And also here also at Panchayat. Job is just to drive the vehicle and nothing more, nothing less. Even then, in the given circumstances, Lordship may consider the situation while setting aside that is a transfer posting order, and authority may be redirected to pass appropriate order in terms of this pending representative.
Okay.
That is my prayer before this honorable.
So that can be disposed of with a direction to the dispose of the representation. Until then, it will, the stay will remain.
No, Lordship, may I submit, Lordship?
Yes.
Lordship, the case of the private respondent, Lordship, the fact is like this, Lordship. The present writ petitioner, he was initially, before joining Tuting, he was posted at Kalaktang. And from Kalaktang in the year 2018, he was posted to Tuting. And the private respondent, he was initially posted at District Hospital Yingkiong. And from District Hospital Yingkiong, he was transferred to Community Health Center Mariang in the year 2019, Lordship. So may I take Lordship to...
So you have
I
been in the
file,
CHC Mariang since 2019.
Yes, the private respondent whom I am representing, he has been in Mariang for the past 6 years. And the present writ petitioner, he has been in Tuting for the past 6 years, over 6 years in fact.
He also?
Yes, Lordship. Now, there is no whisper in the writ petition regarding the tenure. In fact, this honorable court was hoodwinked to pass the order, which I have sought for modification, Lordship. In fact, a vacation of that order. And the private respondent has already joined on 25/4/2025. And thereafter, the interim order was passed, Lordship. And another aspect, Lordship, which Lordship has to consider, Lordship, the state respondent, they have passed this order. And there are allegations that the private respondent had made a request, Lordship. Even if, let's just assuming that private respondent has made a request to the respondent authority, that can be done, Lordship, because he had already served in the place for over six years. And the person who was sought to be replaced had also stayed over 6 years. Now, under the circumstances, when the tenure is over, they do not have any statutory right to claim that this transfer posting is bad in law. And the present transfer posting is vitiated with, it remains vitiated, Lordship, and actuated and effected with malified intention by the state respondent. They cannot say that because initially they have to show that they have the rights. Since they have already completed over since the petitioner has already completed 6 years, how can they claim that they have to he have to be at Tuting? And how can they claim that after serving there for 6 years, they cannot claim because they do not have the right, in fact, to approach this court. He have already overstayed. And considering that both the parties, respective parties have overstayed, I mean, they have already completed their statutory tenure. Considering that the state respondent has rightly passed the present transfer posting order.
So it has to be decided by the state only that since the petitioner and you have completed the tenure, normal tenure, and in the interest of public,
yes,
that can be transferred. But that probably has not done here in the present case. It was this impugn transfer order was issued at the instance of the private respondent.
No, Lordship, that in the transfer posting order, Lordship,
it's not compulsory that the driver should be transferred within 2 years. What is the purpose?
Lordship.
Anyway, yes.
Lordship, another aspect, Lordship, in the transfer posting order, it has been seen that first move at his own request. So it cannot be we cannot say that the The request has been.
It appears, apparently it appears that it was issued at your request, on request made by the respondent, private respondent only.
Lordship,
Hmm.
they cannot take shelter from the inadvertent error made by the respondent.
Now, normal transfer order, what we generally see is that it is in the interest of public only.
Lordship, this,
But here is a case where it appears
Lordship,
from the order itself.
Lordship, my contention is,
Hmm.
even just for assuming that this particular order has been issued at my own request, Lordship, but the statutory period is already over, Lordship. Now, they have been overstaying and
Normally, drivers are not being transferred even after expiry of 2 years, 3 years.
Lordship, that is within,
What technical,
within the district, Lordship, within the district.
within the district?
Yes, Tuting
Maybe-
and then
maybe.
Tuting, Yingkiong, Mariang, it comes under Upper Siang district only.
Hmm.
So within the district that if the competent authority feels it.
Yes, that
thinks
is
it
why I'm saying if the competent authority themselves feels that no, this needs to be changed because things are happening.
And Lordship,
Some things are happening for which the reshuffle of the staff or the drivers is required. Then in that case, in the interest of public, that is always, that can always be allowed.
Lordship, another
That's the
aspect,
department generally that used to do always.
Lordship,
But then here the case where this was issued on the request made by you only, no public interest involved.
Lordship, the another aspect Lordship may consider is subsequent, pursuant to this order, Lordship, the private respondent, he had already joined on 25/4/2025, Lordship. And in
Where
fact,
from you are drawing salary now, till now?
Lordship, till now, Lordship, since I have already joined there, however, because of this interim, from
My
Mariang,
query is,
Lordship.
where from you are drawing salary now?
Mariang, Lordship.
Maria.
Yes, Lordship.
No, you are not performing duty at Tuting also.
Lordship, no.
And then since you have already joined at Tuting, so Mariang also you are not performing any duty.
Lordship, the present petitioner, Lordship, petitioner, in fact, he was on leave, Lordship, when the present private respondent has
And
joined.
now also he is on leave.
Lordship, I do not have instruction with regards to
Mhm.
that. But
Yes,
person,
you are representing department.
ma'am.
What is your submission?
My submission, madam, at first instance, madam, this honorable court was, passing the interim order on 29 April 2025.
Mhm.
Only
29?
29 April 2025. madam.
What is that?
The interim order was passed.
Okay, yes.
In that, madam, the court was on face of record, madam, it was on believing that this has been initiated at the purely on the request of the private respondent. To a certain, madam, the observation was made, madam, just to a certain, madam, at that when instruction was sought for, madam, we could not obtain the instruction at that point of time, madam. So, while passing the order, madam, it was made clear, madam, giving a short period only. The interim order, a short period, madam, to produce the relevant record, only to a certain whether it was initiated on the basis of the request made by the private respondent or not, madam. It was next when order was passed on 29 April 2025, fixing the matter
On 8/4.
Yes, madam. No, on this, the returnable date, madam, the record was kept with me, madam. This is still the original record is with me, madam. And to that effect, we have also filed the affidavit, madam. As per record, madam, there's no any representation received from the private respondent.
Then what is this order? Normally,
that is, madam. I believe, madam, this has been inadvertently how this has been encrypted, madam. And whereas on the record, madam, there's no representation as such.
Okay.
Even that aspect, madam, even petitioner in his petition itself.
But the small remark it says,
Yes,
it shows then
that is why
on his own request.
That is why, madam, only to ascertain, madam, while passing this order, madam, the directed to produce the record, madam. And I have brought the record, my lord, and the record, there's no any such representation received, my lord.
Okay.
Then also we have brought.
Received from the private respondent.
Yes, my lord.
Okay.
There's no record. And to that effect, my lord, even the petitioner in the writ petition itself, para 8, my lord. He has also admitted, man, he has also made on his own assessment, he made an own inquiry, contacted the private respondent and it's on his admitted position that there's no representation made by the private respondent.
Okay.
Now, this is
just verbal request made to the authority.
My lord, that part, my lord, we don't know because it's on,
No,
it's not on
it
record.
is there at
Yes.
his own request.
It's not on record, my lord. So
No,
that's
it's
why
on
my-
record only
Yes.
at his own request in remark column.
Remark column is there, but
Yes.
official report must be we don't find.
This is official record only.
Well, file moving, file noting, but it's not
Okay,
there.
there may not. Yeah.
Original file noting we have, my lord.
Okay.
That's why last occasion, this honorable court was inclined to peruse the record whether there was any noting reflecting the request made by the private respondent. But in the
Then how this initiated this transfer order? In the official
it's
record?
on routine basis only, but it's
Routine
not
basis.
routine because both of them they have completed 6 years in the posting, particular post. They're
No, is a normal practice that the drivers are transferred only after 2 years.
No,
It's not that I think.
as a their ambulance driver, my lord. It was a cross transfer, my lord. Normally the
Then
2 years.
Let it be in the cross transfer without mentioning at his own request. You can understand.
That part
In the interest of because
ultimately, my lord, the guideline,
Okay.
policy transfer.
Okay, anything else?
Policy guideline that has to be adhered, my lord. Since
Okay.
they have already overstayed more than 6 years.
Okay.
So that's why, my lord, and as
Yes,
per the earlier order, we have in the record there is no any remark, the record showing that it was on the basis of the request made by the private respondent. That aspect, my lord, ultimately, my lord, has already observed that who is to be posted where, madam. It is purely prerogative of the authority,
Yes, sir.
madam.
That is
That can be long, madam, in a series of decision, my lords, aware, madam. In SL Abbas case also, madam. Normally in such matter, my lord, only there's a limited parameter where the honorable court can interfere, my lord.
Yes.
But so far,
Right.
there's a malified transfer and there is a punishment transfer.
Right.
While transferring reducing the rank and arbitrariness and violation. So this the broad categories on the ground which this honorable court can interfere the transfer order. But in the present case, we don't find any of these the element. And as per the affidavit matter, it is a routine transfer. And SL Abbas matter, even there's matter, it is ultimately it is the authority who is to look into and where to be and who is to be transferred, where posted. It should be purely left to the authority.
Right.
Just SL Abbas matter are just so for reference.
Yes.
There are 7.
Yes.
Who should be transferred where is a matter for appropriate authority to decide. Unless order of transfer is vacated by malified or is made in violation of any statutory provision, court cannot interfere with it. While operating the ordering transfer, there's no doubt the authority must keep in mind the guideline issued by the government on the subject. Similarly, if a person makes a representation with respect to his transfer, the appropriate authority must consider the same, having regard to the exigency of administration. The guideline says that as far as possible, this is in respect of a joint transfer posting. But the bottom line, the important point is that who is to be transferred where, it is to be left to the authority, discretionary of the authority, and there's only the broad categories, malified transfer, violation of statutory. But in the present case, there is no such the element in the present transfer posting, even in file noting also.
Okay.
This is one, my lord. Then, my lord, the same as SL, that is para 4 of Silpigon. My lord, in a present case, my lord, the authority has considered, my lord, that aspect in terms of SL Abbas, my lord. They have considered the policy guideline for transfer posting, my lord. 2 years. Now, since both of them have already overstayed more than 2 years, that they have been staying for 6 years, my lord. That is the administrative exigency, my lord, for routine transfer is required, my lord. That's why this has been issued. And para 4, my lord, is even assuming there's in our opinion, the court should not interfere with the transfer order, which is made in public interest and for administrative reason, unless the transfer order made in violation of any mandatory statutory rules or on the ground of malafide. Government servant holding a transferable post has no vested right to remain posted at one place or the other. He is liable to be transferred from one place to another. The transfer order issued by the competent authority do not violate any his legal right, even if the transfer order is passed in violation of executive instruction or order. The court ordinarily should not interfere with the order with the order. Instead, affected parties should approach the higher authority, the department. If the court continues to interfere day-to-day transfer order issued by the government and its subordinate authority, there will be a complete chaos in the administration, which would not be a condition to the public interest.
Yes.
I could overlook these aspects in interfering the transfer order, madam. This is, madam,
one more. That's enough.
that's only, madam. Only that part only. Para 7 and 8. Madam, the broad categories, the para 7 is been, madam. This can be unless, madam, order is shown to be outcome of malafide exercise. This repetition part, madam. And normally, but in this case, madam, I don't find, because as per the court order, madam, we have brought the original file noting, madam. There's no indication as such for them. The only reason they cited that both of them have already stayed more than 6 years. That is why they have initiated this cross transfer.
That is in a record.
Yes,
of file.
yes, madam.
Where?
It is original recorded speech.
Just flag that one.
Yes. Note 26, note C26. Red mark we have. File noting, note C26 is file noting and 51 is order. NX 26 is noting. Region is there already overstayed in the file note.
Okay. On the same day, it was proposed
Yes.
approved and signed.
Yes.
Interesting.
Within the district only, within this, and is the ambulance driver, madam. That if it transfers to be made, it's to be at earliest, as early as possible and without any delay. And there's no other, only these 2%, madam. They can be cross transferred to, because there's no other, any other driver.
Your file note says that in respect of other, it took time, but here in one day, everything happened.
My lord, that's, but
the record
only
says.
to show, my lord, what was the reason, my lord. Reason so far, nothing is concerned, my lord. Representation part is not there.
I've seen.
Yes.
There is a gap of 1 month also in other, in
Yes, in other case,
respect of other case.
Yeah. But
But then here, in one day,
ambulance, my lord. Ambulance
Okay.
urgency is
it travel,
ambulance urgency is required.
it travel with the siren. Okay. Yes.
My lord, that's
Okay.
my humble.
Hard, Mr. Tapak. Okay. This is item 18.
11.
11.
11.
Apparently. Okay. The IA is okay. Filed by the respondent only. That is why. Mr. Itapak, Planning Council for the petitioner. So I also have Mr. Tagum. Tagum. Tagum is a standing council for.
Yes, standing council
For
department representing respondent 1, 2, and 3.
the health department. Representing respondent number 1, 2, and 3.
Yes.
Okay. And Mr.
Etatak.
Planning Council for appearing on behalf of the respondent, private respondent number 4. Okay, I'll pass order. Okay.
Deeply on that.
Return.
Item number 13.
Lordship, at this stage, Lordship since private respondent also filed affidavit stating that Lordship they paid the money as agreed upon. As agreed upon with the landowner. So in this case, kindly see page number 30. This is the agreement. Can you get page number 38? This is type copy. The type copy may be seen.
Just a minute.
Annexure C, page number 36 is the agreement copy, and type copy is page number 30. Page number 30.
Just a minute. Just a minute.
Page number 30. What happened, Lordship? May I submit, Lordship?
38.
Yeah, page number 30.
What is this?
This is the agreement in between the landowner and the contractor. This contractor has agreed upon with the landowner saying that he is ready to pay 50 lakhs of rupees to the land affected person over the project. Project is a government project, and this MS Chenge construction has been awarded the contract work by the government, the government department. And what happened in such type of scheme, Lordship, in a nutshell, is
So the contractor agreed to pay
yes,
compensation of rupees 50 lakhs
yeah.
to the landowner affected
This is yes, exactly. That may be
from where?
from own pocket, Lordship.
On pocket.
On pocket, because saying that generally as per this relevant provision of law, this is as per the guideline. This scheme is based on the this PMG SY guideline that is applicable. What happened in PMG SY scheme? The land is to be procured by the government by way of donation, by way of settlement, and there is no there's a provision for land compensation. In that event, government is the duty bound to manage either from the contractor by own donation, by public meeting and gathering. The government has to convene. Otherwise, don't settle. The private, in case private land is to be acquired, the government has to follow the due process of law. But in the instant case, no procedure is followed to resolve the whole issue. Megan, the contractor has been appointed and the contractor has took the risk, has taken the risk, saying that he will resolve the local issue. Accordingly, this agreement has been done, saying that I will look under all those problems, local problems, and work has been awarded. But in this agreement, the private respondent has already filed affidavit stating that this money of rupees 50 lakhs has been already released for payment of the affected land affected person, where the government is supposed to, if government has engaged the private contractor is supposed to approach me saying that I am ready to pay. He should negotiate with me. But failure of which, if private respondent is not ready to pay me over my land, then it is the government, it is a bounded duty of the government to pay land compensation against me.
You said that there is no provision for payment of compensation by the government?
No, that is the government of India guideline. It doesn't say, as per the PMGSI guideline, it doesn't say if land ability, generally land to procure a government scheme under the PMGSI guideline. The bounded duty of the department, it's a procuring department, is to produce land availability certificate. The government has already produced land availability certificate to the competent authority, the government of India. That is why the project has been sanctioned. When the project is sanctioned, it is the duty of the government to procure land from me as per the land compensation, relevant provision of land law. They cannot impose.
Whether respondent has filed affidavit?
Yes, government has.
Yeah, filed.
I am filed, Lordship. I am for the private respondent, Lordship. Actually, in this case, what happened, Lordship? This case is since 2024.
Today. Have you received the affidavit?
Yes. Today.
Today.
Yes. Government has not filed anything, but private respondent has filed stating that.
Government is also filing.
Not filed.
I have not yet filed. My lord, if the petitioner's case is that to implement the agreement between the contractors
No, that is
and
not
the land owners, then department have nothing to do with it. Since in PMG projects, there is, as of today, no compensation is given. So if there any of the, during the course of execution of the work, if any individual's land or property is affected, then there used to be a local arrangement. That is up to the contractors. So department had nothing to do. So if, as per their agreement, they have agreed to pay 50 lakhs, there we have nothing to do, department. If it is his case, then we need not to file any affidavit also. Then if there is a more than that, then we may need to file affidavit.
So you have, the contractor promised you to pay, not yet paid.
I'm saying,
Huh.
I do not have any duty to negotiate with the private respondent.
But
because
you have already,
duty of the private-
you have already
Duty of the private,
entered into agreement and executed the agreement
No,
also.
I have not made any agreement with.
So what is this then? You have just shown.
Agreement is.
This is
with
this
private
fact, Lord.
respondent and the.
Whether he is a land,
Not me. My
that
land-
area or not.
What is this agreement of settlement?
Settlement, Lordship, after the
Contractor
work
and the-
awarded, Lordship. Work awarded to the, in this case, Lordship, I remember, Lordship, this case is, I followed this case, Lordship, since 2024, Lordship. Series of cases in this connection was filed, Lordship, before this honorable court, Lordship. Series of cases filed, Lordship. In that case, Lordship, donations was done, Lordship. Governments acquired the land availability certificates through the donation, deed of donations by the landowners of the project affected area, Lordships. And after that, Lordships, everything is as per the law, Lordships, as per the guidelines, Lordships. And there is no provisions for land compensations as per the guidelines, Lordship. But government has to adopt other means. In this case, Lordships, government adopt the deed of donations. So land affected persons donate the land for the projects. Accordingly, Lordship, sanction was done, Lordships, for the project, Lordships.
Who sanctioned?
Sanctions, Lordship, Government of India, Lordship. Sanction
For-
order is
For the
available.
purpose of land compensation
Not, Lordship, not land compensation provisions is not.
is not there.
Yes,
Then-
that's Lordship.
Hmm.
And in their RTA reply, Lordships, the government reply, dear RTA reply, Lordship, there is no any provisions of land compensations, which is in the record, Lordships. In their RTA reply, government replied the RTA, Lordships. And in this prayer, Lordship, and after, Lordship, award of the work, the land affected persons, Lordship, disturb the project, Lordships. Having no option, Lordships, the contractor, Lordships, settle the deed of agreement, Lordships. Through deed of agreements, Lordship, contractor settle, Lordships. Lordship, if Lordship may peruse, Lordship, deed of agreement, Lordships. Accordingly, Lordship, deed of agreement, Lordship, may kindly have page 38, Lordship. Page 30 is the deed of agreement, Lordships. Page 36 is type copy, Lordship. Type copy is annexure 38 and 39, Lordships, is a type copy, Lordship. As agreed, Lordship, agreed upon the parties, Lordship, of the represented by the land affected persons, Lordship, and the authorized representative, Lordship. Private respondent number 7 is the authorized representative of private respondent number 6, Lordship. Accordingly, Lordship, this agreement is entered, Lordship. As per this agreement, Lordship, 50 lakhs was handed over to the check through check, Lordship, hand over to the land affected parties, Lordship. And work is carried out, Lordships. And Lordship, if he claim for the compensation, Lordship, he need to make a party, Lordship. This party, Lordship, affected persons, Lordship, enter on behalf of the land affected person, Lordship, whom, Lordship, the respondent, Lordships, handed over the check of rupees 50 lakhs, Lordship.
Handed over.
Yes, Lordship. And which collected, Lordship, which collected by the land affected person, Lordship.
You have been handed over.
No, Lordship. That is their money, Lordship.
His claim is that, Lordship, he is not given a money by the land affected persons. His share is not given.
I'm not claiming from the private respondent. I'm claiming from the government, saying that my land has to be acquired. If government is to take my land.
Now, are you in this
My-
agreement?
Very important. Kindly see, to clarify the matter, kindly see, page number 29 order. This is a sanction order. Sanction order says SOP is there.
No, Lord,
Page
agreements,
number-
No, I think,
Page-
well,
page
we
29.
have a limited time, so we'll have hearing on this. Okay,
Kindly, Lordship.
because he is disputing.
Interim order may be passed, Lordship. In case money is released, bill is released, then I will be no here, Lord.
Para 4 of
Against
his
the private
petition.
respondent.
Para 4.
Therefore,
My lord may peruse it. Para 4, married.
yes.
The petitioner begs to state that agreement of settlement dated 25 to 2025 was entered into for payment of land compensation amounting to 50 lakhs. Only with land affected group of BBP Road led by one Sri Lokam Tapo. Upon the agreement settlement, the private respondent number 6 and 7 agreed and assured to pay any outstanding liability of land compensation with land affected family of the BB Road, Nampe to Nisuk promptly. But no payment is also made to the petitioner even after entering the agreement of the settlement, the private respondent. Now, if he have any grievances, he has to ask to his groups who have already received the money.
Agreement, kindly see, agreement should not. I'm not a
So
party.
according to you, 50 lakhs was already released.
I'm not a party.
Okay.
he is not party, but on
Party
their
in the
behalf,
agreement
Lordship, land affected person, Lordship,
No.
the land is settled by,
No.
it is on pocket, Lordship, not by the government, Lordship.
At this stage, Lordship, interim order may be passed against the Lordship, private respondent.
What
Because-
implement?
Interim, kindly see, my interim order, Lordship, interim prayer, Lordship. Otherwise, Lordship, bill will be released. And
No,
if they
private
can-
respondent, private, you are representing?
Private respondent.
Lordship, I am representing private respondent, Lordship.
Against the
But
private
Lordship,
respondent.
how he is locus, Lordship, of the
Construct,
tender, Lordship. He is no.
contractor.
Yes,
Contractor,
Lordship.
against the
Contractor,
contractor.
how he is agreed, Lordship.
Release
It
a,
is not a compensation amount,
No,
whatever the.
then the agreement was between contractor and
contractor.
the
Affected people.
land affected.
Yes, land.
You are one of the land affected.
I'm land.
You are not the
I'm
party.
Under the agreement.
Hmm?
Under the agreement in between this land. Yes. Because land is not one land, Lord.
That
My
means
land
you have
is
no
separated. I'm one of the affected.
Then this 50 lakhs is for which
50
which
lakhs
land?
is for them and party, contractor and the party.
Okay, not for you.
Yes,
Not
not
for
for-
him.
That is why, Lord, this petition.
After disturbing, Lordship, of the project, Lordship, locally settled, Lordship, that is on pocket, Lordship. Therefore, Lord, petitioners have no locus,
That is
to
my.
disturb my bill, Lordship.
In
In
the
tender
money
matter,
To ensure that there are no further objection or disruption to the execution of the work. See, it
Yes.
appears that it's for the entire work. We'll have hearing.
Interim
No, interim.
order may be considered on next day.
What interim?
Interim is
by what
over, bill may not be released. This is a contract.
If they executed
You
one
said that
bill
it's
has
not
to
a
be-
bill against a bill by the government.
Yes, bill
It's a
by the government,
contractor.
because
this is bill is the contract work, Lordship,
if the money is
not for
released,
compensation, Lordship.
if the money is
bill is
released,
for-
I will be nowhere, Lord.
You filed money suit against him.
This,
Yes, Lord. This is
the
the-
government is duty bound to pay me, Lord,
Because,
since they are acquiring my land.
and then you filed money suit against the person who has received your, taken your share also,
Yes.
Oh, Lord,
if he has released.
government has not paid anything,
Okay.
Lord. That is the issue.
Mr. Tapa, Land Council for the petitioner, who submits that he has just received the affidavit filed by the private respondent. Okay. Then you want to file any rejoinder? Okay. And wait for some time to file affidavit in reply.
Government has given substance for filing. Otherwise, Lord,
Okay.
it is lingering the.
But government submits that they are not filing any affidavit.
If his case is regarding
Whether
that
government is
agreement,
ready to file or not, that may be asked. Lord.
Lordship, in this case, there is a deed of donation, there was a deed of donation. So
Government is not
Okay.
ready to file anything. That is okay.
Lordship.
Government is filing or not? Now you have asked.
we'll file then.
Okay. Mr. Mr. G. Tarak, Land Standing Council for the Department, RWD. prays for further 2 weeks' time to file affidavit in opposition. They are allowed. List this matter after 2 weeks. All it's
Matter number 17.
Yes, Lordship. On the last occasion, CD was called for, Lordship. Wherein, Lordship, here both the parties claiming the same plot of land, Lordship. So what the IO did, Lordship, he make a different aspect of investigation by submitting a requisition before the assistant commissioner for field verification, Lordship. Now field verification report is waited, Lordship. So
Field verification report.
yes, it's still awaited, Lordship. So till report, Lordship, till report make up this matter may be Lordship, right?
Okay. Mr. Roilana PP submits that in the present case, during investigation, the IO of the case has the IO has made a
Adopted the different aspect of investigation by submitting requisition before the assistant commissioner to verify the
during
land.
pendency of this petition. The IO has submitted requisition before the
Before the assistant commissioner, Lordship,
assistant commissioner
to engage field technical assistant for physical verification.
requesting to engage field assistant.
Field technical assistant.
Field technical assistant.
Assistant, yes,
Assistant
Lordship. Assistance.
to assess the
Assistance, Lordship. Field the staff, Lordship. Field technical assistance.
yes that I have recorded
Yes, Lordship.
For what?
For physical verification of the land, Lordship.
for physical verification of the disputed land
Yes, Lordship.
to ascertain for physical verification to ascertain the real ground of the land,
Yes,
to
Lordship.
ascertain the fact of the fact.
Yes, Lordship. Since both the earlier occasion, Lordship, someone under 194 was issued to produce the document, Lordship. But
Field verification for what?
for verification of the disputed land, Lordship. Since both the party claiming the same plot, Lordship.
Then it amounts to settlement through mail.
Lordship, since FIR was registered, Lordship,
Okay, to ascertain the fact of the disputed land.
and both
And
the
they-
party producing the document,
And the
Lordship.
same is, and wherein both the petitioner and the respondents are also directed to submit their respective documents. Stuff. The said report is still awaited and therefore pray for some more time.
Lordship.
Okay. The prayer that is not been objected is allowed. Stuff. List this matter after
4 weeks.
after 4 weeks.
Madam,
Okay. Okay, then
admission bill.
okay, then petitioner, you're
Your
good.
Lordship.
Delia,
I-
Lana Council for the petitioner and Mr. Bag. For the respondent. number-
Your Lordship, Your Lordship.
For the complainant side.
Complainant are also present. So, yes. Are you also here in this case?
Yes. Yeah, for respondent number 2, private respondent, Your Lordship.
And the amicus curiae.
For respondent number 2?
Yes, Your Lordship. My name may be recorded kindly.
Okay, you are for respondent number 2?
Yes. Yes, private
Then
respondent.
who will represent, amicus or?
Amicus was appointed by the court. On that day I was absent, your lordship.
Okay, now since you are appearing,
Yes, my lord.
Yes.
so amicus will no longer appear in the case then.
He's not required. I'll be representing the private respondent, your lordship.
Okay, then Mr.
Biswajit Prasad.
Okay, Lana Council. You are appearing for the first time?
Yes, I'm appearing for the first
Okay,
time.
would appear on behalf of the private respondent number 2. Since Mr. This is appearing on behalf of the respondent number 2, Mr. Bagra, who earlier appeared.
Yes, my lord.
Mr. Bagra, amicus for the respondent number 2. Okay, the present of Mr. Bagra, amicus, who are for the respondent number 2 may no longer be required. Okay.
Much.
Yes, your lordship. A date may
Okay.
kindly be fixed, your
Start,
lordship.
then as played for as requested by the parties. Let this matter be listed after
4 weeks.
on after 4
On
weeks means
16 for your lordship.
holiday. That is holiday. Okay. 29/4.
29 for. No, my lord, on 29 I have a matter.
For April.
Yes.
This is March only, huh?
Yes. On April, my lord.
Okay, when?
Matter may be fixed another month of May.
May.
Yes.
Give date.
4th May.
4th May. Okay. Okay. The registry shall reflect the name of Mr. So and so as counsel for the respondent number 2. Okay.
Much obliged.
Obliged.
Item number 18.
My place, my lord.
Bagra's
So,
appearance dispensed. Okay. Yes, now.
So, my lord, the actions of pleading, so far the actions of pleading is concerned. It was completed in the December 2025. Now the matter is ready for my lord disposal.
It's there. Okay, then it's fine. Yes,
Now the matter is ready for disposal since the actions of pleading already completed by the
Okay.
December 2025.
Item
Item 18, my lord.
My lord,
18.
my lord, the reply is still pending, I guess, maybe.
My lord, I have received the reply on behalf of the sole respondent.
Yes. May I, my lord?
Yes.
Affidavit करेगा, ऐसा है?
Affidavit. You have already filed reply.
My lord.
No. I have filed it. I am the respondent side, my lord.
Respondent. You have filed
Respondent has
affidavit.
already filed.
Okay. You want to file reply?
No, my lord. I don't prepare, my lord, any
Okay.
just reply in the
May I, my lord?
affidavit in the reply, ma'am.
Okay. Well,
So,
then
so my lord,
we'll
since the
get
matter is listed in the
admission column.
order status, my lord, so I need to, my
What is
lord,
this
take the
case about?
permission from both the party to my lord
Petitioner is, my lord,
to
they have
dispose of the
filed-
matter.
dispose of the DB matter which is pending before the JMFC UPR,
What
the
matter?
domestic violence matter,
Okay.
pending before the judicial magistrate first class in UPR for quashing of that case, my lord. My lord, in their petition, they have very clever.
No, my lord, first of all, what my lord, I am trying to sort from this honorable court and the other party, my lord, since the matter is ready for disposal, my lord, if my lord permitted, my lord, I have to start my argument, my lord. This will be the.
No. We'll get it listed in admission column. We'll try to dispose of them.
My lord.
We have less time also. There are other.
In such
My lord, this-
situation, my lord, this matter may be on.
This case is very simple.
Okay.
They, if my lord may give me only
You have
for 2
you have objection.
Yes, I have already filed my
Okay, what is the case registered against you? DB. What is the allegation then?
allegation is that my lord 2023 we have the respondent wife have filed an FIR
Okay.
and as far the settlement that FIR was quashed in 2023 from this honorable court. Now,
FIR was quashed.
no, yes, from this High Court.
Okay.
So
Have you annexed that order?
order.
My lord, I'm the right person to, my lord, this,
Just a minute,
first,
just a
my
minute.
lord. If the matter is going to be disposed of,
Yes, yes.
Just a minute, huh? You said simple. Is it simple?
my lord,
Will it be,
according to me, my lord, this
can you,
is
can you
not,
complete within 15 minutes?
no, my lord, it will take her, at least, my lord, 30 minutes. I will record 30
If
minutes.
Your Honor will give me, I will finish it only in 2 minutes, my lord. It's a very simple, it's a settled law, it is a very simple case.
Okay. Yes.
May I, my lord?
2 minutes.
Yes, only 2 minutes, my lord.
Okay, let us try.
Okay, before arguing my reply, I would like to place a judgment, Your Honor.
My lord,
Page
my lord,
number-
I should be given first.
Just a minute, huh? In
I'm-
2 minutes, if I can
Yes.
understand, I'll give you time.
My lord.
Page number 3, my lord. I have already highlighted that the para. May I read out, my lord?
What is this? Okay, yes,
Page number 3. May I, my lord?
yes. First, I think I need to know the case.
Okay, my lord. This case
So
was
what is
filed.
this?
This
Which is
petition
going
was
to start
filed.
in 2 minutes, huh?
May I, my
Yes.
This petition was filed by the respondent husband in the court of High Court of Punjab and Haryana High Court, asserting that for quashing of DB case in a matter that they have objected.
Before Punjab and Haryana court.
Yes, yes,
By the husband.
yes. For the quashing
Okay,
of DB
where
case.
the DB case is lying pending?
As far the story summary, it was pending before the Punjab Magistrate Court.
That is separate court, a separate case?
Then also the matter of case is very similar to our case. May I, if my lord
Okay.
may give me a time. My lord.
Okay.
So what happened, my lord? The husband filed an petition before the High Court, Punjab and Haryana High Court, saying that the FIR, the wife had filed an FIR, and also accordingly, the wife had filed a DV case. So they are saying the course of action is same, but the High Court, the Punjab High Court has given a very good judgment that even though their IPC is a penal law, my lord, and the DB case is a civil remedy. So even though there is both the matter is come out with the same course of action also, well, it can be simultaneously, it can be go side by side, my lord. So as per their petition, they are praying that already the FIR case was quashed by this honorable court in 2013. So they are praying in this petition that taking that FIR, they are trying to quash the DB case also, which was relief remedy given by the judicial magistrate for only for a monetary violence under Section 3 of Domestic Violence Act. So they are trying to quash that DV Act. DV case filed before the JMFC court.
So the simple is that you have an objection
Yes,
for quashing of the DB case?
yes.
Okay,
So
understood.
they are
So the-
already,
So this is prayer for quashing of the DB case?
yes.
What is at what stage the DB proceeding is going on in the?
Sir,
for the magistrate?
my lord, in DV case, we have prayed monetary relief, not apart from the monetary relief from the husband, from the petitioner, praying that in a shared household, under DV Protection Act, shared household, we have, my husband is voluntarily, deliberately, he had stopped giving EMI. For that loan, we have combined a loan in the house taken
We'll
from.
get it listed on Thursday.
My lord.
Okay.
In
We'll
a-
dispose of on that day
my
or
lord.
tomorrow also. Okay, not today.
In admission column, my lord.
Okay, that is why I'm saying. Okay, heard Mr. Modi, C. Modi, Ghana Council for the petitioner. Also, Miss, also heard Miss
TZIM,
T.
ZIM.
Ghana Council appearing on behalf of the respondent. Staff. the pleadings are completed. List is, since the parties are duly represented and the pleadings are complete, list this matter again on Thursday for admission. Okay?
Obliged.
Obliged.
Item number 20.
Okay.
Good evening, sir. My lord, I am appearing in person related to my own case. The case is termination of my service. Actually, I was appointed in as an assistant manager in Arunachal Pradesh Rural Bank. And my lord, they first served me the SOCOS notice, and after that they terminated me merely on the SOCOS notice. My lord, the SOCOS notice is completely different from the termination letter. In fact, there are some points that have been added in the termination letter. My lord, page number 52 is the SOCOS notice.
Just a minute, sir. Have you filed affidavit?
Yes, Lordship, yesterday we have filed our affidavit.
Have you received
reply.
affidavit?
Yes, sir.
Okay, then we'll be place it on for admission. Okay?
Lordship.
Actually, my lord, I want to say that.
You want to file reply to the
No,
affidavit?
no, my lord. I
Okay.
just want to argue.
Okay.
My lord, I have something to say.
Hmm.
I am since 1 year. It's going to be almost 1 year for this termination, and since then I am facing a lot of financial troubles and everything, my lord. I have dependents in my family, and moreover, my lord, I am appearing for some other exams also. I requested on 9th March also on which my case was scheduled. And my lord, for appearing those exams, the eligibility criteria is that I should have the no objection certificate and experience certificate from the bank, and they are not serving me. Because my lord, so disposing of this case becomes the urgent need for me, my lord. Because I feel that this is totally, they have, this termination letter is completely an illegal termination. They have only given me the SOCOS notice, no any departmental inquiry, nothing was done. In fact, the SOCOS notice is completely different.
Terminated for what reason?
My lord, in SOCOS notice,
What
they
is
are
the ground?
on fraud, my lord. And there is not a single rupee fraud. Even if they prove me just
Fraud.
1 rupee fraud, I am going to take this matter. I am going to accept my defeat right now. Page number 52 is the SOCOS letter.
No,
my
no,
lord.
no FIR was lodged against you.
My lord, actually they tried, but my lord, the police didn't register the FIR, saying because it is only related to account opening and it is the administrative purpose, so we cannot lose the FIR.
FIR was not registered.
Yeah, but in the investigation letter, they have said that we have told the branch manager to lodge FIR against me, means to me.
Okay.
My lord, if you please allow me just 10 minutes, my lord.
No. Today, even if I hear you also, we will not be able to dispose of due to paucity of time. Okay. So
My lord,
next week or this week, any days.
My lord, even tomorrow I am ready, my lord. Because my lord, on
What is
February, on April, in the mid, I am appearing for interviews, and recently I cleared the SBI.
When the interview?
My lord, the date would come any time because I have cleared the mains.
Okay.
And if I don't get the NOC and everything, I'll miss the opportunities also. My lord, they have done some kind of investigation, they claim, and the investigation report itself says that there is no any fraud. But in the termination letter, extra points have been come and fraud has been mentioned. My lord, for punitive kind of termination, there must be all departmental inquiry, charges must be issued. In fact, our rule book says all these things. They have not done everything, my lord.
The respondent has filed affidavit in opposition, to which and a copy has been received by the petitioner in person staff. Considering the submission made by made by the petitioner in person, that there is an urgency considering the urgency expressed by the petitioner in person, let this matter be listed up to 2 weeks.
So 2 weeks would be more than enough. my lord.
When?
In this week, in this month, any date, my lord, please.
Okay.
2 weeks
Then-
is more than enough, my lord. In this month, any day. I am ready for tomorrow also, my lord.
6th. Okay. Okay. 6th, huh?
So 6 would be,
6 April.
the 6, I think we, this one, my lord. If I may be called for interview, my lord. Please on this month, my lord. I request you, I plead to you, my lord. I given a just, my lord, just 30 minutes, my lord. I could prove my innocence, my lord.
31 April, huh? 31st April. March. Okay.
31st March. Thank you, sir.
For admission. Okay.
Thank you, my lord. Obliged.
Matter number 22.
Your Lordship, I'm open IA for impleadment of. They need to file reply.
Your Lordship, we have received the parawise comment, Your Lordship. May I pray, Your Lordship, I may be allowed 1 week time to file our affidavit, Your Lordship.
Okay. So implement for who? Of
State Secretary Panchayat, since this matter related to a Panchayat, yes.
okay. You have not
I have not implemented that.
Secretary Panchayat.
Yes. Lots.
No objection. Can be implemented.
Yes, Your Lordship.
Okay. Mr. There. Deori, na?
Yes.
DK Deori, Land Council for the applicant. Also heard Mr.
Why Ram, Your Lordship?
Riram for Riram is for
1,
yeah?
2, and 3, Your Lordship.
Okay, respondent number 1, 2, and
4 and 5.
no. Okay, 1, 2, and 3, and Mr. U body for respondent number 4 and 5. Start with para. This is an application filed under section 151 of the Code of Civil Procedure 1908, seeking impleadment of the state of Arunachal Pradesh through Secretary Panchayat Raj, Government of Arunachal Pradesh, as respondent number 6, being necessary party for proper adjudication of the subject matter in this in the writ petition number 49/2026. Start. The prayers so made being not being prayers so made not being objected to by the Honorary Counsel for the petitioner is allowed. Stop. Accordingly, the
I will be allowed to add in the cost title.
allowed, with the allowed, accordingly, the Secretary Panchayat Raj, Government of Arunachal Pradesh, is be impleaded as respondent number 6 in writ petition number 49/2026. With the above, this IA stands disposed of. In the main, Mr. Deori. Also heard Mr. Rira and then Deori has them. Okay. In view of the order passed today in IA number 78 AP 2026, the Secretary Panchayat, same, okay, is included as respondent number 6 in the present writ petition. The petitioner, the petitioner said file amended course title by inserting the name of the newly impeded respondent, newly impeded secretary so and so as respondent number 6. Stop. Oh. Then after implement only you take the steps.
Yes, I will take the steps.
Okay. Then you amendment course title you file within a week.
Within a week.
Okay.
And
thereafter, within another week, the petitioners shall take steps upon the newly implemented respondent by a speed post as well as by user process within another week. Stop.
Standing council is there.
Standing
For
council.
Panchayat.
Standing council.
Yes, yes, Panchayat for Panchayat.
Okay, then
Yes, I will-
you just first amend them. Okay.
Yeah, on the interim is there till next date.
Okay, the interim list is matter after 3 weeks. The interim order
Eight.
pass earlier shall continue till the next date, huh?
8 of April.
8th of April. Okay. Then, as requested by the parties, let this matter be listed on 8 April. Stop. Till then, the interim order pass earlier shall continue. Okay.
Obligation.
Matter number 23.
कौन सा एक सेकंड हम बोल देते तो हमारे प्रेजेंटेशन इसको तो बाई से और यो यूनियन एक में बोलने का कोड wait please your lordship my lord.
Yes, please.
My lord will take the main case, my lord. Don't take the IA, my lord. We are not pressing the IA at the
So
present.
this is IA.
IA we are not pressing at the present. Please take the main case, my lord.
Okay.
And see the prayer. It's a land acquisition matters at page 21. See the prayer at page 21, Roman 1.
Page 21.
21. That's a prayer. It's a land acquisition matter, my lord.
Yes.
A writ of mandamus or certiorari and or other appropriate writ or direction to respondent to consider the case of the petition or resurvey of the properties between so and so for widening, improvement of existing road. A writ of mandamus directing so and so dispose of the representation on the basis of letter dated 18/10/2024 issued by respondent to survey of horticulture, agriculture, structure. That's our case. Now, what they have done, we filed representation, but they have not disposed of for resurvey of the matter. Last representation which has filed on 30/12/2024 at page 338. 338. I will not ask your lordship to adjudicate the matter. He's only let the deputy commissioner adjudicate, my lord, at page 338. That is 30/12/2024. This is our representation.
Okay.
30/12/2024. That's the last representation which we have filed before the deputy commissioner. My lord will kindly see this 30/12/2024. Lordship got it?
Yes.
Humble prayer to comply with the order of director issued on 18th October 2024 and resolve the matter at the earliest. So what we have done on 17/12, kindly see the first, my lord, undersigned back to state on 17/12/2023. 17/2, it should be 17/2.
Where do we find?
My lord, first paragraph.
Okay, yes.
That's the undersigned back to state that on 17/2 it should be, because if your lordship kindly see at page 28. Please see page 28, my lord, for a moment. This is 17/2. Kindly see at page
But this is
28.
your representation?
My representation, my lord. Several representation was filed. We got compensation,
but certain components we have not got. So page 28, this is what we have referred. See, kindly see subject, prayer for resurvey of property falling under so and so, so and so. See the last paragraph, therefore, the district along with other concerned authority conducted property assessment survey several times. However, the manner in which the final property assessment prepared by so and so is very arbitrary. Now, please see page 30 now. These are type copy at page 29. These are we not, so we have typed out. Please see page 30.
28 is also type copy.
30 is also typed because it is not legible. It is typed. Page 30, my lord, kindly see, is continuation. In the said assessment, many of properties under Walong Township of project affected family falling under proposed sketch of land needed for widening have been left out, and some declared as illegal construction without affording us of being heard. Moreover, what is more shocking is some of the structures, specifically double-story building which Kanpur has been recorded, is legal, and the upper floor of the same is marked as illegal. So what we are saying, my lord, at page 338, so my representation for resurvey, they will consider, my lord, as per law, my lord, your lordship can dispose of and ask the state government to resurvey, because at page 338, what we sought for is that my joint representation which has been filed, they should dispose of in accordance with law. And they can form a committee, and accordingly, if I'm entitled, I'm entitled. At page 338, my lord. Your lordship will not adjudicate this matter here, because ultimate deputy commissioner has to adjudicate for resurvey.
Yes.
My learned friend, I think my state is there.
Your Lordship, in that case, Your Lordship, the representation may be disposed of. That
Okay.
may be given to the deputy commissioner, Your Lordship.
Okay.
And in that representation, whether resurvey will be done or not, it will be decided by the deputy commissioner.
Okay.
So our liberty should be given, our person hearing should be given to us, my lord. At the time when the resurvey is done, our representative also will be present at that time. So they have to be present also. So we have to be present. Disposed of.
My lord, I put the Union of Vidya, madam. For reconsider, my lord, for consideration of representation and disposed of, my lord, we don't have any objection.
Okay. Hard, Mr.
My name is not there in the cause.
Yes, sir.
I will engage Mr. Das.
National Council, assisted by.
I thought Mao is there.
Okay.
Mr. Mao is there. So
And Mr. S. Mo, National Council for the petitioner. I want to have. Your correspondent number? Mr. Kato,
Union of
Correspondent number 528, madam.
Okay, and Riram is for,
124, Your
okay, Mr. Riram. Riram is a standing council,
No, Your Lordship, government.
sorry, government advocate for respondent number 124, and Mr. Kato. And a DFTI for respondent number
528, madam.
528. Okay, Kato, fair.
the synopsis is there, man. I made a synopsis also. Immediately after list of dates. Okay.
the case of the petitioner is that, sorry, the petitioner is aggrieved by their horticulture, agriculture, structure, and other assets are being, this is affected by construction.
Yes, widening of the road.
For widening of,
Yes. My lord will
where do we
widening,
find
yes.
widening, huh?
This deputy commissioners are notified for conduct of land for widening, improvement of existing defense road.
Widening improvement
Improvement of existing defense road, second
of
paragraph,
existing,
third paragraph, to an HDL specific road in respect of so and so. Lordship got it, my lord? On the first, second, third,
Mhm.
Deputy Commissioner Anjao notified for conduct of land survey and property, assessment for widening, improvement of existing defense road to so and so of road in respect of so and so for constant defense road by Grave and has carried out joint survey. This is. And so and so. And on 1810, the Director of Land Management has written to DC referring to representation letter dated 12/8 submitted by DC Anza Director on 12/8/2024. Deputy Commissioner has forwarded a representation filed by the petitioner to the Director Land Management, stated that the petitioner claimed the property was not properly assessed during the earlier survey, and Chairman of the board formed for assessment of the property structure has made several errors in the LA estimate. On 13/12/2024, petitioner has filed a representation to the DC Anjao while praying for resurvey and inclusion petition land which is illegally taken out by the respondent. Petitioner has stated need for land, road is 24 meters. However, the authority have just assessed 15-meter distance. On 18/10/2024, written by Director Land Management Government to the Deputy Anjao.
This detail not required to be, I think.
No. My lord will kindly see that there are representation which has been
The
filed.
representation will say that you have the petitioner has submitted representation on such and
For
such date,
resurvey,
which is yet to be for
disposed of,
resurvey.
for resurvey,
Mm.
and which has not been disposed of.
Yes.
So the authority will take a call on my representation, and only an opportunity should be given to us, my lord, within a time-bound manner, my lord.
Okay.
My lord will kindly indicate
Just a minute.
at page 24, this is a notification.
Just a minute.
At least that has to be indicated.
Okay. The case of the petitioner is that on 27/4/2021, the government of Arunachal Pradesh, Department of Land Management, Itanagar, has issued a notification wide number LM 212/ACQ/2021 stop. The notification was issued under the section 10 of Balipara Tirap Sadia Frontier Trade Zoom Lane Regulation 1945. Stop. It is submitted that the Deputy Commissioner Anjo wide letter number ANJ LM 83 LM-83 stroke 2018 19 stroke 1521 49 dated 13/7/2020 notified for conduct of land survey and property assessment for widening stroke improvement of existing defense road to NHDL specification of road in respect of Changwinti Namti from kilometer 00.002 45.450 for construction of defense road by Griff. Start. The case of the petitioner is that while making the assessment, certain horticulture, agriculture, structure, and other assets were not taken into consideration. And therefore, they filed representation before the respondent authority. However, the said representations, how many representations you have submitted?
Two.
We don't, okay.
Two representation.
Okay. Has not is pending disposal. Before which
Before
authority?
Deputy Commissioner Anjao District.
The Deputy Commissioner Anjao District. Start. You have filed affidavit also?
Yes.
No.
Government has filed affidavit.
No.
I have filed.
Okay.
Yes.
What is your contention in the affidavit?
If you see at page 362, paragraph 4, page 362, paragraph 4.
The respondent government has filed affidavit. '64.
Page 362. 362. This is more.
It is only up to
360.
360. 62 page 62.
362, page 362 of the government.
In the affidavit.
Affidavit of the DC also.
Okay.
Respondent.
Yes.
By DC.
Para?
Para 4 kindly see my lord.
Okay.
The answering is breakthrough. There is no error in assessment of horticulture. But however, some of the property was assessed, but not compensated. As per the board parameter, 362 will continue at 363.
And fairly contended that there is no error, they say.
No error.
Okay.
But
contending that there is no error in assessment of horticulture, agriculture, and structures. However, the respondent further contended that some of the property was assessed but not compensated as per board parameters for land acquisition process issued by the competent authority.
so against that, we are here, my lord. It should be resurveyed.
Start. Okay. Then, prior to this only, being aggrieved, the petitioner filed this writ petition. seeking direction
Page 21.
to the respondent authority to consider the case of the petitioner for resurvey of properties between Changwinti, Walong, there's Namti from same kilometer, 00.00 to kilometer 54.450 for widening improvement of existing road to BRO. Stop. Then get government's submission. Okay. However, at this stage, Lanachino counsel for the petitioner submits that since the representation submitted by the petitioner is pending disposal before the respondent deputy commissioner Anjo, the same may be directed to be disposed of in accordance with the provisions of law. Stop. This writ petition may be disposed of with the direction to the respondent authority to dispose of the representation submitted by the petitioner. Dated 30/12/2024. Start.
For resurvey.
For resurvey and inclusion of all the standing properties within bracket assets.
Yes.
And horticultural crops, Chawingti des Walong des Namti Defense Road. Stop. The Land Council for the respondent has no objection to the disposal of the writ petition to the extent that we direct the respondent authority to dispose of the representation submitted by the writ petitioner dated 30/12/2024 in accordance with law. Okay. Then in view of the above.
Yes, it
Okay.
will be above.
Okay.
Opportunities will be given to us also.
This writ petition is disposed of with a direction to the Deputy Commissioner Anjo to dispose of the representation dated 30/12/2024 submitted by the petitioner. How many petitioners have submitted?
71.
Okay. By the writ petitioner, 72 in numbers for resurvey and inclusion of all the standing properties, asset and horticulture crops, Chawni Walong Namti Defense Road. And by giving an opportunity to the parties for hearing.
Yes.
Okay. Sorry. Then within
period of
within a period of 45 days.
Yes.
Okay, 45. Okay. Then in their submission, after giving sufficient time to the respondent authority. Okay. Then within 45 days. Okay.
After the receipt of the certified copy.
After receipt of the certified copy of this order.
Actually, my lord, it's okay, my lord. Actually, they should form a committee. A committee, deputy commissioner, and
that is their local, because naturally, because
in accordance,
a lot of petitioners.
Yes, that's why.
So before disposing of,
yes,
naturally,
Yes.
and probably he will do that also.
Yes, normally, I hope so.
So that
A
direction-
committee is being formed.
Hmm.
Normally, if a direction is given, because I am not asking to adjudicate the matter by this court.
Right, right.
What I am saying, let the deputy commissioner adjudicate the matter.
Hmm.
Recently, what we have done, one of the case saying that committee to be constituted by deputy commissioner and the representative of those 71 petitioner will also be present. Land management, deputy commissioner, so that they can look into it.
Hmm.
Otherwise, my lord, 72.
You can add if required by forming, by
Committee.
constituting a committee.
Yes, that makes more easier, my lord.
My prayer submission would be, my lord,
Hmm.
since lordship is giving a direction to the deputy commissioner.
Hmm.
The deputy commissioner, while
In a-
deciding the representation
Hmm.
with the, whether further course of the or not, that will be taken into consideration by the deputy commissioner himself.
I don't know whether it will be taken, but when the matter, I am not asking that your lordship will decide the case, but there can be a direction passed by this court requesting
Hmm.
the deputy commander form a committee. If at all it requires advice, so the committee, because it makes more easier to form a committee. Deputy commissioner, additional deputy commissioner can be there, my lord.
But it's
It's up to the court, my lord. I am not pressing this court, but it makes more easier to dispose of.
Hmm.
Because these are 71 petitioner, my lord.
dispose of the representation in accordance with law, my lord. That will separate.
Hmm.
If required, my lord, further action is to be taken, my lord, the initiative is to be done. But definitely, my lord, the deputy commissioner will decide in accordance with law, my lord.
Okay.
Again, I have
In
to come.
accordance with law, huh?
Again, I have to come. That's the whole problem.
Hmm.
So, further, not to
Let
trouble
me
the
see
court.
if it is possible. What we can do is, it will say may only,
Yeah.
if required, the deputy commissioner may also constitute for the proper disposal of the representation. The
right.
deputy commissioner may also constitute.
Yes, may.
Yes,
May, I'll
yes.
use may. Okay,
May.
constitute a committee. Yeah, committee whereby the representation of the representation from the and
Petition.
all the petitioner cannot come.
No. 5
Uh,
fixed representative.
Representative of the petitioner.
Representative of the petitioner.
Consisting of representation from the petitioners, and who else you said? Representation from representative from the petitioners and
Representative for the petitioner and from the other side
okay,
also.
okay.
All the parties will be present. Yes.
With above this, with petition stands disposal. Okay. In view of the order passed, the IA also stands disposal. Okay.
I am deeply obliged, my lord.
Item number 28 and 29.
Lordship, the case matter may be adjourned for Monday. Maybe matter will be
This is-
time, Lordship. It will require time.
It will require time.
Yes, matter may be fixed on Monday.
Okay. Monday.
Yes.
What is this matter about?
This is with regard to pending compensation amount for release of the compensation.
As
pending
requested, okay. Requested by the land council for the parties. This matter next week. Okay.
Right.
No.
And Monday, matter may be fixed.
As a fixed matter.
Yes, as a fixed matter. Otherwise, Lordship.
Sometimes it happens that if we keep a
on
lot of a fixed
we
matter,
will-
it's very
we will
difficult.
try, Lordship. Maybe on then
Monday.
Tuesday.
Okay, on the request of both the land council for the
Yes,
parties.
Monday.
This matter
On Monday.
on 30, on Monday. Okay.
Okay.